Lordship, in item 5, Lordship, my friend has filed an affidavit, Lordship, on 6th.
In item number 5,
I pray for 2 weeks further time. I'm going to respond.
what affidavit, Mr.
As for the court's order, Lordship, he has filed an affidavit.
Okay, so you need to respond.
Yes, Lordship.
Then counsel for the respondent has filed an affidavit in reply. Affidavit in, when did you file it?
He filed it on 6/9.
In a file, then.
2022. 6/9/2022.
On 6 September
6 September.
2022.
22.
When
22.
Ms. Chaudhary, a request doesn't seem to be feasible. Then,
I'm very sorry, Lordship. Lordship will take it up.
pass. Don't adjourn.
Lordship?
He is not seeking adjournment now in this circumstance.
Lordship.
No, but
No,
What happened?
In fact, Lordship, I overlooked it. Lordship.
maybe some other day, Malad, some other
Okay, Ms. Chetri appearing for the respondent
Tuesday,
submit
on Tuesday, Malad.
that he needs
No,
some
not
time
on
to
Tuesday, Lordship. let it be
prepare
on
and argue the matter. Re-notify. Now it goes to November, Ms. Chetri. Not in this month. 21st November.
Wednesday.
May I please, Your Lordship? Lordship, in from item 24 to 26, Lordship, we are seeking a short accommodation, Your Lordship. There's a personal difficulty today, Lordship. From the
For whom?
from the finance department, Lordship.
Okay. These are 2019 matters, gentlemen.
Lordship, I just,
19, 17.
Yes, ma'am.
Lordship, we are ready for, Lordship, today there's some difficulty, Lordship.
Only counsel representing the finance department submits that there is some instructions are awaited and thus consideration of these matters may be deferred for some time. List on 9th November as played.
Yeah, please, Your Lordship. I beg to mention in item 17, we couldn't file affidavit till now because of non-availability of information, my lord. Kindly 4 weeks time may be
Then
granted.
counsel for the petitioner pays for and is granted further opportunity of 6 weeks to file the additional affidavit.
Obliged, my lord.
List of 6 weeks.
I'm paying for listing of a writ appeal, my lord, some urgency tomorrow, my lord.
What is the matter about?
It was about the medical admissions, MBBS. My lord. Day after tomorrow will be the last date. So I'll take
When was the single bench order passed?
yesterday, my lord, in the afternoon.
Okay, very well. Lovely.
Daily list for orders, item 7.
Lordship, kindly pass over for timing.
Lordship, on the last date, I had sought some time for filing an additional affidavit, compliance report as directed by this honorable court. So Lordship, 2 writ petitions in the single bench were preferred by the encroachers. Lordship had directed that in one of the writ petitions, there is a stay order, in the other, if there is not, you should evict them. I have evicted the other encroacher, Lordship, and the compliance report, I have submitted the same.
What about the setting up of the children park?
Lordship, the possession of the land has already been handed over to GMDA, who has started the preliminary work, but
All right, we'll see. Let the matter be called out.
Lordship,
We'll see.
all right, Lordship.
Item number 8 to 11.
Your Lordship, may kindly peruse the order dated 28/8/2023.
Which matter, gentlemen?
Lordship, in your Lordship, Nippon Dholua.
Yes.
PIL 15.
What do you want?
Lordship, there is a direction to the authority, your Lordship, to place the instructions regarding constitution of town vending committee as well as the vending zone.
Let the matter be called out, Mr. Motaku.
Lordship,
Let the matter be called out.
Lordship,
Right now, mentioning is going on. Mentioning or list? Okay, we have taken up the matters.
Lordship.
Okay. Where is the respondents council, GMDA, GMC? Pass over.
He's on his way, Your Lordship.
Yes, all right, pass over.
Item number 12.
Wait,
Oh,
Your
then
Lordship.
7 also, I was under the impression that mentioning is going. Passed over, all right.
On last question, honorable court has directed me to take instruction, my lord. I have received instruction, my lord.
Is item number 12?
My lord.
Yes,
Yes, what is your instruction, madam?
Lordship, the permission order has been already cancelled, my lord.
Your purpose is served?
Yes, my lord.
The net council, MS, MD Bora has placed on record copy of the communication dated 20th September 23 issued by the additional district magistrate Vojai, as per which, the permission for organizing lottery and sales of gift tickets proposed to be held at Nikhari Mukh Field, Jamuna Mukh, by Jungle Block, by the respondent number so and so, Jungle Block Socio-Economic Development Society, has been cancelled, and the organizers have been directed to refund the entire amount to the collected from the public concerned by way of sale of lottery tickets. First of, the District Commissioner Ojai shall ensure that the amounts in question is refunded to the concerned people in view of the above communication says order, the grievance sought to be ventilated in this writ petition PIL has been satisfied, hence the same is closed.
I am deeply obliged, my lord.
Ek line only. It is further made clear that no such illegal permissions to operate lotteries in contravention of the prevailing statute shall be permitted, shall be granted.
Deeply obliged, my lord.
Item number 13 to 16.
In the item number 13, let us kindly pass over for the timing minute.
In item 15, my lord, the newly impleaded party Rakal Das has been served with notice. I have been telephonically instructed to appear, my lord. As in
Let the matters be called out once.
15 minutes.
Yes, let the matters be called out again. They are all connected matters now.
Yes.
Yes.
Item number 18.
Who's there? Service upon the respondent number 5 has still not been effected. Await return of notice for 2 weeks.
Item number 19.
Hello, sir. I'm for the state, my lord. And my
Where is
friend,
the petitioners council?
he was there, my lord.
Password.
Item number 20.
Yes. Made prisoners. My lord, other grievances are, my lord, by virtue of that were satisfied. The only thing is, my lord, let them dispose of the representation. They have taken on board, but they have not decided, my lord.
So we'll give a direction.
Yes, to
All
dispose
right.
of the representation.
Then council, senior council, Mr. Chaudhary submits that most of the grievances raised by the petitioners in this writ petition have been ventilated after the meeting held, meeting of the state level standing committee dated 22nd August 23.
Yes, my lord.
Full stop. And 19/9/23. However, the Mr. Chaudhary submits that the representation dated
6/9/23, my lord.
at page number
72.
the representation, detailed representation submitted by the petitioners on 6/9/23 has not been decided by the chief engineer, road and bridges within bracket PWD, Nagaland. In view of the submission noted above, requiring the chief engineer Road and Bridges within bracket PWD, Kohima, Nagaland, to objectively consider and decide the representation of the petitioners by a reasoned order within a period of 2 months from today, comma,
Let it be 15 days.
15 days from today,
Fine.
comma, the proceedings of this writ petition, writ appeal are closed.
Deeply.
Needless to say that in case any adverse order is passed, comma, the petitioners shall be at liberty to take recourse of the suitable remedy for ventilating their grievances.
Deeply.
Close wala last wala. With the above suggestions and directions, the instant writ appeal is closed.
Item number 21.
No, please, Lordship. Lordship, this matter may be password for time being, Lordship.
Pass.
Item number 22.
Yes, please.
My lord, in this case, Lordship,
Hmm.
I filed my additional affidavit, Lordship. The copy of the same I could not serve, but today's morning also I called my learned friend or standing counsel,
You filed the affidavit when?
12/9, Lordship.
12/9.
And I served the copy to my learned CGSC, Lordship. And I think it is a question of legal point is involved, Lordship. My learned friend,
Ms. Gupta, you received the affidavit
I have received, my lord.
when?
I have received it, my lord, on 7/9.
but
You are the contesting respondent or the others also?
My lord, now the issue is upon the central government, but because, my lord, they have annexed some resolution of the meeting minutes of the Council of Architecture.
Okay,
My lord,
respond number 1.
yes,
Yes. So now the ball is in the central government's court.
my lord,
So we can proceed with the matter?
my lord.
All right,
Lordship,
start. Who is there for the response number 1, 2, and 3? Mr. R.B. Cohen.
P. Mohanto.
Mohanto, P. Mohanto.
P. Mohanto.
Last date, Mr. R.B. Cohen was there. We don't know. Yes,
I
someone
called
has to
him
be
in the
here.
morning, Lordship.
Your Lordship, I'm appearing on behalf of Mr. P. Mohanto. Your Lordship, he's on legs on another court. The matter may be passed over.
Passed over.
Much obliged.
Find out whether the affidavit filed by Mr. Mazumdar is on record or not. Check. Yeah.
Item number 23.
This is your Lordship.
Yes, please.
Lordship, I'm appearing on the, I respondent number 1, 2, 3, and 4. Lordship, we've already sent the affidavit for vetting and Lordship, may kindly grant us this time to file the affidavit.
Concept for the respondent. Numbers 1, 2, 3, 4, and 6.
My lord, I am appealing for
1, 2, 3, 4.
8. You are appealing for
1, 2, 3, and 4.
1, 2, 3, and 4. Last date you also appeared for respond number 6. All right. 1, 2, and 3, and 4. Praise for and is granted 4 weeks time to file affidavit on behalf of such respondents. DLC. What about respond number 5? Service is complete.
Yes, sir, they are represented, government is represented, the committee is their committee, man.
Is there committee? Yes.
Yes, madam.
Very well. Mr. Azarika appears for respond number 8.
8, my lord.
The other respondents are not represented despite service.
Obliging.
4 weeks time is granted to the council for the responsibles 1, 2, 3, and 4 for filing affidavit on behalf of such respondent. List of 4 weeks.
Item number 27.
Hmm. Yes, you're for the excise department.
Yes, Lordship, I am.
You filed your affidavit
Yeah, yes, Lordship. Second time I have filed.
second time.
Yes, Lord.
Okay. None present for the petitioner when the matter was called out. List up 4 weeks.
4 weeks.
Yes.
Item number 28.
You want to file the clearance certificate.
My lord, the clearance certificate is still awaited. The authorities are on the issue, but they have not yet called that local meeting, my lord. My lord, I only request a prayer, my lord. If my lord can issue an observation, make an observation, my lord, that may help me, because otherwise the revenue of the state, my money, everything is.
We have already cancelled the letter of intent, my lord. And there is a deeming provision. If he fails to deposit within 45 days, it's a legal fiction, it gets cancelled. So because of I have given an undertaking that will not proceed. And that thereby, my lord, we are losing 6 crores of revenue per year, my lord.
My lord, the tender that was issued required me to get those clearances. Normally, my lord, the clearances are got by the government. 45 days time is given to me to change the names. And then 45 more days. Here, my lord, the letter of intent is yet to be issued. Only a provisional letter of intent was issued.
For are they responsible for this dilemma?
Because, my lord, these bodies are their bodies, my lord.
Maybe.
Because
But
I have
But
got,
the NIT, if the NIT clearly conveys that you will have to get the clearances, you have to get them in the time
no,
out.
there cannot be a time prescribed for that, because these are things, my lord, which the authorities on
We
their own.
understand. We
This is central
understand.
government, my lord, they have their own way of doing it, my lord.
Very well, it is his stand that they have cancelled it.
My lord, that's why I'm before your lordship
So
challenging that
we'll
very
examine
provision.
it. We'll examine it as on date.
No.
You are lacking in compliance.
No, my lord. My lord will have the rules. My lord was satisfied. That is why my lord wanted to pass an interim order. My friend, my lord, took the undertaking, gave the undertaking. If my lord can come to the provisions of the tender, my lord
Yes.
would have page 62, my lord.
62. All right.
Lordship.
Hmm.
A, no objection certificate from Deputy Commissioner. That is already in place.
Hmm.
The successful bidder shall have to get a mining plan prepared by and approved by the competent authority as per the provisions of the rules and bear all costs. I have done that, my lord.
Hmm.
The successful bidder shall have to obtain environment clearance and other clearances from the competent authority, Government of Assam, as per the instruction of the Ministry of so and so.
Hmm.
For this, my lord, I am required to make a deposit of around 1 lakh rupees. I have made that.
Hmm.
The DFO has already returned to the authorities.
But
They are, my lord, not taking that matter forward. I'm pursuing that matter with them.
is this process to be started only after the NIT?
Yes, your
Or could
lordship.
it have been obtained in
If-
advance?
If I get it, my lord, then I'll have to go to them and get that, my lord.
After getting.
Normally what happens if my lord can have page 42, I think that will clarify the issue, my lord.
Yes.
My lord would have 10.2C. A 2, my lord. The preferred bidder shall be considered to be a successful bidder. 10.2, successful bidder upon, my lord, C, having obtained the mining plan as per rules and its amendment within a period of 45 days from issue of LOI.
Okay.
Having obtained, now, my lord, why that 45 days? Explanation.
Hmm.
Ordinarily, such clearances under CDA above shall be taken before the bidding process by the state government competent authority. If such clearances so and so have been taken before the e-auction by the state government competent authority department, then cost incurred in obtaining such clearance shall be reimbursed by the successful preferred bidder, and the clearances shall be transferred to the successful preferred bidder within this period of 45 days.
You
Such-
read out. Yes,
Such costs incurred in such clearance may be mentioned in the information document contained in Schedule A.
Hmm.
Further, such time period of 45 days may be extended by the competent authority if the competent authority is convinced that such a delay is not caused on part of the preferred bidder. However, such emission shall be limited by rules so and so as the
So
case.
what do these rules?
My lord, what they say is that if they have got the clearances, everything is in place, to transfer it to my name, I have 90 days time. 45 plus 45.
Hmm.
When there is no such clearances, my lord, then I'll have to go before the authorities.
But there is the time limit is
Time
governed
limit
by
is
rule 17 and rule 22.
22. That also envisages a situation, my lord, wherein the rules, permissions are in place.
Hmm.
Here, my lord, I was directed by the provisional LOI to approach the authorities and get those things done. And I have been doing it, my lord.
Hmm.
Only the environmental clearance by an authority constituted by the government of Assam is pending.
All right, what do you say? How are they responsible for the delay? You have put the onus on them. And your authorities sit tight on with the application. That is a catch-22 situation.
True, my lord. If we, my lord, ignore that portion, my lord, his bid has, LOI has been cancelled also on the reason that he has failed to deposit statutory, security amount, my lord. It has nothing to do with this, my lord, clearances.
Where is that order?
My lord will kindly peruse the order impugned at page, my lord, 213.
Just 230.
213, last annexure, my lord.
Yes.
Last paragraph, whereas under rule 37(3)(1) and 3 of the Assam Minor Mineral Concession Rules, the highest bidder, LOI holder shall deposit an amount equal to 10% and 15% of the annual bid amount as initial bid security and bid security respectively before expiry of so and so. The LOI holder has failed to deposit 15% of bid security within stipulated time, hence rule 37.3.3 is attracted. My lord. So there is a rule. It says, my lord, that he has to deposit certain documents, clearances. I am not on that only. There is a rule that he has to deposit, my lord, 25% of bid as bid security of 1 year's annual lease rent, my lord. He has failed to do that, my lord. Now to cover that up, my lord, he's taking this plea of not getting statutory clearances because of the authorities, my lord. That rule 37, if my lord perishes, it creates a legal fiction. It says, my lord, if he fails to deposit within 40 stipulated period, here the stipulated period is 45 days. Fail to deposit, his bid will be cancelled. So that is automatic in application.
That is not in his control. That is in the control of the government of authorities.
No,
He has applied in term, yes, deposit of that we'll ask him. What about that?
That deposit is envisaged on issuance of an LOI. My lord, in my case, it is only a provisional LOI has been issued asking me to get those. That is at page 75. This is the, my lord, the fiction they are trying to create. My lord will have page 75.
The final LOI obviously would be issued after you.
Only
you
after
present
this,
deposit the security.
and the period would be 5 years.
Depositing the clearances.
Yes, my lord. My lord will have the last line, last paragraph. Therefore, you are requested to issue a provisional letter of intent to the so-and-so has been asking to ask the highest bidder to prepare, submit the following documents. You are further directed not to issue final settlement order. Next page, my lord. You are further directed not to issue final settlement order or order for so-and-so, final order for diversion of so-and-so issued by the central government and environmental clearance is issued by CI. It is now pending for CI clearance, my lord. And the contract, the tender itself, my lord, envisages 5 years contract from the date of issue of LOI. Now I am only on a provisional LOI, which I have to get it. Now I have done everything. I have invested money, my lord.
But let the clearances come, then we'll decide whether you are in violation of the rules or not.
Lordship.
Yes, all right.
My lord would only make an observation, my lord,
Then
if the
Council
government.
Mr. Nair submits that the petitioner has taken all steps and made the deposits for the clearances in terms of, for procuring the clearances in terms of clause. Where is the NIT?
10.2, page 42, my lord.
Clause 10.2 of the NIT bidding document, but the concerned authorities of the, which is the authority?
My lord, it's called SEISCA, my lord.
You can give it in right.
I'll give it in
Yeah.
writing, my lord.
Has still not
Granted.
taken a decision on the said application.
Environmental clearance, my lord.
Environment to grant environment clearance to the petitioner. He urges that this burden has been cast upon the petitioner in terms of the explanation below clause 10.2 supra, under which comma.
But not that, my lord, not there. In the tender document, my lord would find that.
Page 42 explanation below that.
That is for that when it is already in place, my lord. My thing would be, my lord,
You said that the government has to procure normally.
the government normally has to procure.
He urges that under the explanation below clause 10.2, comma, it is provided that normally the government would have to procure these clearances, but in the event of the bidder being required to procure the clearances, comma, he has to move the competent authority, which the petitioner has done long back. Full stop. He thus urges that a direction be issued to the SEIAA Assam, State Environment Impact Assessment Authority, Assam, to process the application of the petitioner expeditiously. Full stop. Mr. Goswami submits that the LOI issued to the petitioner has already been cancelled by fiction of law. To this submission, Mr. Nair submits that by as on date, no final LOI has been issued to the petitioner, and thus, the question of depositing the 15% of
The bid security.
the bid security and the cancellation of the LOI does not arise. Be that as it may, these are issues which will be gone into when the writ petition is being finally heard and decided. For the present, we hereby require the SEIA Supra to expedite the decision upon the application for clearance submitted by the petitioner. List up 4 weeks.
The undertaking will continue, Malad.
The undertaking given by Mr.
That will always.
Goswami will continue.
Much obliged.
पहले फ्रेश मैटर होता दे दो सप्लीमेंट कर
Supplementary list, item 37.
Your Lordship. Lordship, a similar matter came up last week
Hmm.
and your Lordship was pleased to grant interim protection.
Yes, issue notice connect with so and so. Interim protection has been granted to the respondent.
Yes, your Lordship.
Yes.
The petitioners, your Lordship, appellants.
Respondent in this appeal.
Yes.
So we'll connect your file with those appeals.
Yes, your Lordship.
You don't take this order. You don't take this. Yes. Connect with writ appeal number 363 of 2023.
Lordship, protection is given to the appellants, not to fill up the posts. Direction is to the respondent not to fill up the post.
Okay.
So
The-
protection is to similarly situated appellants.
On parity, it is here, maintaining parity, it is hereby directed that the post in question shall not be filled up till the next date of listing. Re-notify on 6/11/23 along with summons.
Oblige, your Lordship.
Item number 38.
May it please your Lordship.
Yes. Yes.
Your Lordship, the appellant falls in the category of 6 candidates who were notified that they were not selected for the CC 2018 examinations because they had not cleared the preliminary examination.
Mhm.
This against the order dated 21st August 2023, your Lordship.
Mhm. What is the ground of challenge, madam?
So
What is the ground of challenge?
the ground is that, your Lordship, when the candidates had initially.
Well, it's
cleared
the same
CC
matter.
It is
All
the
right.
same matter, your Lordship.
Same order.
Much obliged, your Lordship.
Item number 39.
Yes.
May it please, your Lord.
Against an interim order sort of.
Yes, my Lord.
So what is the grievance?
My lord, my house, I'm the landowner of a certain plot of land, my lord.
Hmm.
They are being acquired for expansion of the highway.
Hmm.
I'm not against the highway project at all.
When?
My lord, what I prayed for, there was a dispute as to the assessment of the house, of the house and properties, my lord.
For
uh,
that, you have already approached the arbitrator.
I have approached the arbitrator.
Then-
There was an order by the arbitrator not to demolish the house and thereafter to go in for assessment.
Mm,
My lord, as against those orders of the arbitrator,
mm,
the respondents, my lord, they have come up in the writ petition, my lord.
mm.
There are two legs of my submission, my lord. The first, my lord, it is an appealable order under the Arbitration Act. So they could not.
Who has
have
come in
approached-
appeal?
My lord, the Union of India.
In writ petition or in
writ
appeal?
petition, In writ petition.
In writ petition, okay.
The first leg of my submission, my lord, is that this is an appealable order and therefore a writ petition could not have been filed
Appeal lies to whom?
to the district judge, my lord, the principal civil court.
Okay.
That is the first leg, my lord. The second leg of my submissions, my lord, is that since it is a highway project, I understand, my lord, there must be some urgency on their part.
Mm.
There was an order by the arbitrator, my lord, directing assessment. That could be, my lord, I'm not against demolition of my house, not at all, my lord. Let my house be assessed, my lord, and thereafter the demolition. Because if the house is not there,
Yeah,
what will be left
what
to
will
us?
be the evaluation?
My
Yes.
lord.
Lordships, in this case, Lordship, I am appealing for the writ petition and in the writ petition, my lord. They filed the application for non-payment of proper compensation, my lord.
Mm.
And accordingly, learned arbitrator has passed the order that not to demolish the order.
Yes.
Lordship. They
Till
want
the evaluation is done.
Yes, Lordship.
So why don't you go for the evaluation?
Yes,
What is
Lordship,
that? Is it a rocket science?
Lordship, that is already done, my lord. That is reflected in the impugned order, my lord.
Where is it done? They have already done. Move the arbitrator that we have already
Lordship,
evaluated.
problem is, my lord, that post, arbitrator post is now abolished by the government, Lordship. That is the problem, my lord.
So you have to
Well-
file an appeal.
Lordship, we have already requested, Lordship visited the office also. We have filed stay vacating application for modification of the order also, Lordship.
Is it correct that the arbitrator's post has been demolished?
Yes, Lordship, that is.
Has been,
the
then-
report, Lordship.
Then what is the remedy?
My lord, the state government has, they have to appoint the arbitrator, my lord, the central government. The state government has to nominate, earlier, my lord, this is because of the, my lord, merger of divisions of
No.
the,
Okay.
my lord. So the
So
state
arbitrator
government
for
has-
this particular area has been,
Yes, my lord.
okay,
That is the
Abolished.
Central Assam Commissioner, my lord,
okay.
Commissioner of Divisions.
Hmm.
My lord, the assessment which my learned friend is talking about, my lord, is by the state PWD on a previous rate. My lord, it has to be on the date of taking over possession. My lord, on the
Get
date
a fresh evaluation done. We'll give you permission.
Yes,
then.
my lord.
Lordship, that evaluation is already done by the, as
No.
per Right to Fair Compensation Act 26, my lord, that is reflected in the order. Kindly peruse for a moment.
Oh,
my
that is why they have gone against that, being dissatisfied by
Lordship.
that evaluation.
Yes.
They have a right.
Lordship, their assessment is to be done by the competent authority, my lord. That is done as per Right to Fair Transparency Act 26. my lord.
Then why do you provide for arbitration then?
Lordship,
Why do you provide for arbitration thereafter? If the evaluation once done
Yes.
is final, what is the meaning of the arbitration proceedings?
no, Lordship, thereafter, Lordship, the abolition was done, my lord.
Let us see the arbitration application.
Lordship.
Where is that?
Peruse for a moment, page 79, my lord.
Yes. Read.
Yes, my lord. An application under subsection 5 of section 3G of the National Highways Act, Lordship.
Mm.
Lordship, kindly peruse for a moment, Lordship, National
Yes.
Highways Act, my lord. National Highways Act, my lord.
Read the contents of the application.
3G5, my lord.
What is their prayer?
Lordship, if, as per 3G5, my lord, if the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable,
Yes.
either of the parties, the amount shall on an application by either of the parties be determined by the arbiter to be appointed by the central government, Lord.
Yes. So arbitrator has said that I want a re-evaluation done. What is the problem?
No, Lordship, they approach the arbitrator for, yes, my lord, for compensation, and that has been already done, as per assessment has been done by law.
Oh, my goodness.
That is reflected in the order, my lord.
Yes, counsel, then what is the use of appointing an arbitrator? If your assessment is final, what is the purpose of an arbitrator?
Competent authority for land acquisition, I am appealing for him, my lord. And he has, my lord, on the basis of structure as per the 20 Department SLC. On the against that, my lord, arbitration, the person can approach the arbitrator, and he approached the arbitrator. Now the arbitrator post is not there. So, my lord,
So there means your demolition, deprive him of compensation.
regarding my lord, only point, my lord, determination of compensation.
For determination, he says that the evaluation which you have done is not satisfactory.
My lord,
He has a right to say so.
my lord, but
Then-
petitioner himself, my lord, what is the structure that has already been measured? Only the rate, my lord, it is whether it is on the basis of 2014. PW rate or 2021 PWD.
Yes, yes.
Only on the basis of rate.
Mm.
Well, if the building is also demolished, well, on the basis of the documents which we have already,
Mm.
it can be determined. Only
Yes.
by the compensation amount is already required to be determined by.
What do you say?
My
The
lord-
rate will ultimately be determined on the built-up area.
My lord.
That built-up area has been measured.
the
So the
built-up area is-
arbitrator will decide
My-
what is the rate to be applied.
My lord, what I would say.
Petitioner has already annexed it as page 30, my lord, of the appeal memo, my lord.
Mm.
What is the structure? He has already, all these things are there. Only the determination of the adequate compensation on the basis of the structure.
Yes, Mr. Nair.
My lord, what I may propose, my lord, if my lord comes to page 174, my lord,
Mm.
the second order passed by the learned arbitrator.
Yes.
My lord, he has directed, my lord, the second, this is under section 17 of the Arbitration Act, we had approached the arbitrator. But
Yes.
the third paragraph,
Mm.
I have gone through the petition and after careful examination of the record, it is expedient to direct the valuation officer income tax, CPWD, that's a uncadred officer of the CPWD, my lord, to assess the market value of the buildings, houses of the petitioner at the rate applicable as on
Mm.
31/11/2020. What I may propose, my lord, that this authority may be directed to.
Measurement is already done.
No, my lord, not by him. By the Kala, my lord, the competent authority of land acquisition, my lord, by a state PWD, they have.
But do you have any dispute in the measurements done by them? Let us
Yes,
see.
my lord. Yes.
Where
my
have you said so? In your
lord.
application?
Page 11, my lord.
Yeah, in your application. Then you
page-
would have to raise that
Yes, my
issue
lord,
in the
we have
application.
raised that.
Let's
The
see.
application. Page 94, my lord.
Mhm. Yes.
My lord, seventh line from the bottom of the paragraph before table A, my lord, starting
Mm.
with therefore. Therefore, there exists a dispute between the parties herein for not properly assessing the applicant's residential houses, buildings,
So
houses and
that's,
structures.
that's a dispute of
Yes, my lord.
proper assessment,
My lord.
not of measurement.
Uh,
Measurements are already there.
no, the assessment, listen.
Hmm.
My lord, what I may propose, my lord, if if an authority, an independent authority is directed to do it within a period of 7 days from today, my lord. If the CPWD is directed, my lord, within 7 days from today,
Who's there for we don't know. CPWD is not before us.
not before,
Then-
not before. It's not a party, my lord, but the direction was to the CPWD.
Lordship, as per act, that to be decided by the competent authority, like that's already done, my lord.
That is the
Ah.
dispute.
All right, then we'll stay the proceedings. We'll keep the proceedings stayed. You are adamant.
Lordship,
Then what is the arbitration for?
Lordship,
It's utter nonsense.
My lord, actually, may I also?
Yes, please.
And I say, with due permission only. I want-
Yes, please,
Because
please.
it's a question of public importance because road is.
We
very- I'm
understand.
coming
We
before
understand. But
others not
he's
doing.
adamant on his
Here,
stand.
what happened, my lord?
Yes.
The entire land is acquired under provision of NH 19 National Highway Act 1956, my lord.
Mm.
As per provision, notification is issued 3A, then declaration was 3D. Before that 3C was objection was to be filed, that is all been finalized. According to 3A petition, as soon as after declaration, the property belongs to central government, my lordship. Then
Yes.
after that, it is coming only, thereafter only coming 3G, my lord.
Yes, 3G.
3G5. Now, if amount determined by the competent authority is not satisfied by the either of the parties,
Mm.
that is be me NSADCL
Yes.
or maybe he.
Mm.
Now may approach the arbitrator under section provision of section 3G5. That is my appointed arbitrator, my lord.
Mm.
Now, why before lordship? Because my learned friend has filed because repetition, why, my lord? That is the only question is coming. Because we have challenged the order passed by the learned arbitrator under section 17 of interim measure.
Mm.
That is for we are heading. Now under the provision of section 37(2), we supposed to go for vacating to learned arbitrator.
Not
my lord.
on that
Lordship,
issue,
lordship,
Constable.
only time being.
He
Why we have
simply
come, my lord?
says,
No, no,
make
my
a
lord.
proper measurement.
No, that is a-
Assessment will be
that
done
is a-
later.
that is a- my lord, if arbitrator would have been there, if arbitrator would have
We
been there,
absolutely understand that, sir.
now what happened, my lord? 3G5 decision, measurement is already over, only he's according to own application, it is a compensation. Compensation part, that will be decided, because they will pay.
He is disputing even the measurement done by you.
But that is.
So have a measurement done.
Under.
It is rocket science. It will take 2 hours. Suggest an authority,
Under
get a fresh
3G5,
measurement done.
Their prayer is not a compensation only.
Evaluation on the basis of measurement done.
Lordship, within a period, Lordship.
Well done.
Suggest the name of authority, simple as that.
Independent authority, man.
CPWD, all right.
They have a valuation wing, my lord.
Is it okay? CPWD?
Yes, ma'am.
My lord, in the earlier, my lord, the arbitration appointed the income tax officer, evaluation officer, he, my lord, evaluated
Yes.
it in a some other.
No, no.
Yes.
Oh.
So even in this case, he has
Yes.
appointed the valuation officer income tax.
My lord.
He can also, my lord, he can also. do
He
it.
may
All
be
right,
directed,
who's there for the department? Mr. KL. Let's call Mr. KL and we'll issue that direction.
my lord.
Simple as that. What is the
My lord.
big deal about
The
it?
road can be constructed, my lord.
Yes, yes, we
Foundation
understand.
one, We have already received the foundation one, he has already referred to the petitioner.
We understand. If there is a dispute regarding measurement,
Yes.
have it resolved. It
It
takes
can
2
be-
hours,
can
what
be-
more?
My lord, it can be reviewed in the presence of the petitioner by the.
Yes.
My lord.
Petitioner and your representative. All right. The dispute intercept between the parties is regarding parties to this writ appeal and the writ petition, caption writ petition is regarding valuation of the petitioner's house, appellant's house, which has been acquired by the NHI for the purpose of such and such road. First up, the construction of the road at the location where the petitioner's house is built, appellant's house is built, is stuck up on account of the order dated 2nd May.
My lord, 19th
April 23,
Yes.
passed by the
Arbitrator.
commissioner cum arbitrator appointed under section 3G5 of the NHI Act. First up, by order dated 2nd May 23, the arbitrator has directed that the valuation officer income tax shall assess the market value.
Also look into the section 29 of 2008, competent engineer, the word used in the statute is competent.
So that's why we are saying let the CPWD
Yes,
do
my
it.
lord, that will be the better.
Give us the act, directed the valuation officer income tax to assess the market value. Valuation officer normally, Mr. Council, valuation officer of the income tax would normally be an outsourced engineer, basically.
My lord, he's from the CPWD. The evaluation officer income tax is an enquadred officer of CPWD.
Empanel officer, so that would be an engineer. Valuation officer income tax to assess the market value of the building / houses / structures of the petitioner at the rate applicable as on 3/11/2020. It may be stated that the post of arbitrator has in the meanwhile, in the intervening period, been abolished by on so and so, and thus, the proceedings before the arbitrator are held up, thereby, the construction of the road in question is adversely affected. In view of the peculiar facts noted above, we hereby direct the valuation officer income tax / the evaluation wing of CPWD to forthwith and not later than within a period of 7 days from today, carry out the valuation so as to assess the market value of the building, houses, structures of the petitioner in terms of the order dated 2nd May 23, supra, full stop. The copy of this order shall be provided to the competent authority of CPWD by within 2 days, whereupon, the authority shall appoint a suitable date within the next 5 days. First up, the parties, that is appellant's hearing and the representative of the NHI may remain present during the valuation proceedings.
That's evaluation and measurement, my lord.
Evaluation and measurement, as well as valuation proceedings. This is valuation which has been directed by the arbitrator. As soon as the valuation proceedings are completed, the ad interim stay order passed by the arbitrator shall, on the demolition of the building of the petitioners, shall stand vacated. The writ appeal is disposed of in these terms.
My lord, till then it may be continued, my lord. Otherwise, there may be some question of.
As soon as
My lord,
we have
my lord,
qualified it very clear.
my lord, deeply obliged.
The writ appeal is disposed of. As well as in.
Item number 40.
Lordship, in this case, I was supposed to file an affidavit, Lordship. It was on my officer is out of the,
But
is on.
we would like to know, why was the essay got dismissed? You are in item number, this is Pradeep Kumar Verma.
No, my lord.
That is the matter which has been called out, sir. Item number 40.
40. Oh, I'm sorry, my lord. I thought it was 14, not 4.
Yes. Why was the essay got dismissed?
Dismiss for non-prosecution here.
Then
Because
there is no way out then. That was the place where you could have satisfied that you have made the requisite deposits.
subsequently we have deposited that we have deposited.
Subsequent deposits, we are not bothered, sir, then. You may have done so many things after that.
Contact of the bank is not good because there is a contact.
You have filed an FIR, prosecute that. Writ jurisdiction, sorry.
We have filed an FIR, you also, your lordship, and you.
So, all right, take your remedies. Why is this court going to delve into disputed questions of facts? You have made the deposit against that account, any other account. We are not going to verify that.
No, because your lordship shown the statement I have annexed, your lordship, that we have entire deposit, your entire amount, and the principal that I have deposited, your lordship. Page
So
90.
you were supposed to show it to the DRT. Why didn't you do that? You had filed an application, you were negligent. You could have kept the application pending, made the deposits, and got an adjudication in your favor. Writ jurisdiction, you know the limitations. This is the yesterday's judgment.
Lordship, yesterday I have perused your lordship, yesterday's judgment, but that judgment is practically something.
Is on a some little bit of different
Different, your lordship. because
factual matrix,
the-
yes.
The authorized officer misleading the district magistrate and obtain this into order. And your lordship, the letter of that bank authority, your lordship, page 38 candidates.
Do you have a remedy under the act or not? Writ is not a remedy, sir.
The fact is that they have misled the court, obtained, I have against.
These are purely disputed questions of facts. Whether you have made a deposit or not. Unverified statements.
I left out the DRT till that 15 days time I get it till that protection. We approach the DRT,
Approach, who stops you?
some protection we given because.
No
there is
protection
order-
is required. Go to DRT. They will give you the protection.
Because this order is passed, it is total not go to the. Order passed the district magistrate on the basis of false statement given by the bank
So-
authority because they are given the statement.
So are we going to verify the truth or otherwise of the statements in writ proceedings?
It's that their statement is there, their letter subsequent to this order. into
Are
order.
we going to verify those things, sir, factual aspects? Is it permissible? Go to DRT. If you have a remedy there, go and file. Dismissed. Disputed questions of facts. Yes.
Okay.
Password. Madam.
Passed over meter, item 7.
Let's see what your report
In
is.
this case, we have to file a affidavit because two petitions are filed by the same party. One petition is dismissed on the same ground, same impugned order. Another petition is filed by in his personal name, Gopal Mandal. So my lord, I have to file an affidavit. Order was not complied with, only half of the order is complied.
And counsel, Mr. Saikia submits that the order under contempt has not been fully complied and is desirous of filing an affidavit to demonstrate this fact. List of 6.
Obliged.
So as to enable the petitioner to file the requisite affidavit. 6 weeks, 6 weeks time.
Item number 8 to 11.
Lordship, in this case, your lordship is taking up the issue of prosecution of the town vending committee, lordship. Yesterday, they have informed me that one name from the home department is pending, lordship. And within the next 7 days, they are sending one name, lordship. And the next 15 days, the committee will become.
Committee will become functional.
Yes.
Mr. Naik, appearing, standing counsel, GMC makes a statement that the process for constituting the town vending committee is at an advanced stage and would be finalized within next 15 days. Re-notify on 16th November.
Lordship, another issue of vending zones is also your lordship is.
That once the committee comes into functional, becomes functional, then the next process will follow.
Obliged.
Item number 13 to 16, fast over meter.
Please, your lordship. Well, in item number 13 is a petition. Your lordship on the last occasion granted time to the respondent to file affidavit.
Yes, Mr.
Affidavit is almost, he was out of the city, lordship, on official duty. He has not come, lordship. To Manka, sir, he has not.
How long?
You were on official duty.
Lordship.
Sharma, praise for further opportunity of 7 days to file the affidavit in terms of the direction given on 11th, in terms of the order dated 11th September. List of only. What about the other matters?
My lord, item number 14 and 15, my lord, these are regarding, my lord, settlement of fishery. During the pendency of the writ appeal, my lord, the fishery has been settled. And my lord, those persons, my lord, have been, my lord, and I has been filed for impleading them. Now, we have also, there is justice service, we have filed an affidavit saying that they have refused to accept, my lord, both item number 14.
But if the settlement, is the settlement under challenge in these writ appeals?
Yes, my lord.
Okay. You said that during pendency of the appeals,
Yes, my
the settlement has been made.
Yes.
Does it not give rise to a fresh cause of action?
My lord, in fact, there was an order that even if the tenders are open, the settlement should not be given, and that is why, my lord, the
Contempt is there. All right. Okay. Let's see. 14, 15.
Item number 14, my lord, again, I-8 2023, that is an impleadment application. And the affidavit has been filed on 31st of August saying that, my lord, he has refused the stay.
He is the person to whom the settlement has been granted.
Yes, my lord.
Okay. You are appearing. You are appearing for whom?
I'm appearing for impleaded person Rakhal Das.
That is in item number 15. my lord.
15 minutes.
Okay. Item number 14, who is the impleaded person? Mr. Chaudhary?
Person is, my lord, Subrata Sarkar.
Subrata Sarkar. IA number so and so. The notice of the impleadment application. Where is the note of the refusal, sir?
The affidavit, my lord.
Here our settlement money to come. I'm not ready to give up.
Lordship. My lord, the originals are at page 17, my lord, but it has been recorded that he has not received.
The notice of interlocutory application number so and so was attempted to be served on the respondent number 1, who is sought to be impleaded in this writ appeal. But as per the noting on the return notice, such respondent refused to accept the same. Hence, service is complete. Heard on the prayer for impleadment in view of the fact that during pendency of this appeal, the respondent number 1 to the IA has been granted the settlement in question, he is permitted to be impleaded as a party respondent in the connected writ appeal number so and so. Amended cause title be furnished within 7 days. Notice will again have to go in writ appeal.
Or maybe, my lord, my learned friend, since they have given the settlement, they can.
You can, then counsel Mr. Sharma shall ensure that intimation of the pendency of writ appeal is provided to the respondent, or we can issue a notice and ask him to get it served. Let notice of the writ appeal number so and so be issued to the newly added respondent and shall be served through Mr. Sharma, Standing Counsel, if Fisheries Department, AFDC. This is item number 14.
14, my lord. Now in 15, my lord, my learned friend appears.
Yes, he has already appeared. Yes.
Although he also refused.
Okay. In 15, Land Council so and so puts in appearance on behalf of the respondent number,
Yes or no?
impleaded, newly impleaded respondent so and so.
I need copy, my lord.
A copy of the writ appeal be provided to him. List along with so and so
Highly obliged.
in second week of November. No, rule returnable करना पड़ेगा ना उसका notice. Rule is made returnable on date of which is 16th November. There is one more, this Nisar Ahmed, 16.
In that case, my lord, we have taken the steps, my lord, to Dusty, my lord. And
To
we'll
the-
file the affidavit by next week, my lord, we'll file the.
Okay. 16th November, simple 16 कर देना.
Pass over meter 19.
Please, lawsuit, my friend has to submit more than he may submit, otherwise, I should start my argument. I'm for the set.
You want to start the arguments.
Or either the appellant will start, because last time he. started.
Normally, that is the norm that the appellant's counsel or the petitioner's counsel should address the court first. If you have some anxiety, then you can
No,
do
no,
it.
why not? The last
Okay.
time it was in part.
Last time, no, we have not marked it parted. Matters which are not admitted cannot remain parted.
Yes, but.
Anyhow,
There is one caveat there, they can be discharged now.
a caveat will discharge once the Zakir, give me a fresh diary.
No, last one.
Yes.
Please, Lordship. Lordship, as I addressed last time, the perversity of the order impugning the judgment, Lordship, may I directly take Lordship to page number 63. Para number 29. Lordship, just married.
You will have to recapitulate the entire scenario.
Yes, that is what I'm doing, Lordship.
Yes.
Learned single judge, Lordship, it says the Lordship that the petitioner was also member of the Autonomous District Council Ukhrul in terms of the election of Autonomous District Council Ukhrul. But he was never been appointed as vice chairman of the ADC Ukhrul. Later issued by the chief executive officer, Ukhrul dated 21/12/2007. It's a mere letter communication between the chief executive officer ADC Ukhrul and the principal secretary and Hills Government Manipur. And it can be taken that he has been appointed as vice chairman ADC Ukhrul during the tenure period of the ADC from 2015 to 2020. The petitioner has not produced any document to prove that he was functioning as vice chairman of the ADC Ukhrul. When he failed to produce any document to show that he functioned as vice chairman of the ADC Ukhrul, then he has no right to invoke section 9 of Rule Manipur Hill Area Council Rule 1972. Once the tenure of the elected member of the ADC has expired on 30/11/2020, this petitioner cannot claim that he was the member, vice chairman of the Autonomous District Council, and he may be given in charge of the caretaker chairman of the council, since the question of appointment of vice chairman to the post of chairman does not arise. There was no vice chairman at the time of the appointment of the caretaker chairman. The real effect of Rule 9 will operate as long as the term the member of the ADC expires, Lordship. What is it, para? Learned single judge says the Lordship. In the writ petition filed by the present appellant, there was no any document to show that he was ever elected as appointed as a vice chairman of the ADC. Number one. Number two, Lordship, the term of the ADC
having been expanded in 2020, applicability rule 9 is not there. Rule 9 will come into play only when the life of the agency is there, my lord. First part, Lordship, my lord, and shall Lordship, may I take my lord to page number 107. Page number 107. Last time also I have taken this Lordship theory. Lordship 107. This is a communication from the Chief Executive Officer, ADC Ukhrul, addressed to the Principal Secretary.
Page 177.
107.
107.
And I say A2 on the within bracket A, small a. Lordship, phone it.
Just,
Page 107.
yes, please.
This is a letter dated 21st December 2007 from the CEO, ADC Ukhrul, addressed to the Principal Secretary. As directed by your letter number dated 11th December 2017, election of Vice Chairman Ukhrul Autonomous District Council was held at the Council Hall of Autonomous District Council Office Ukhrul on 20 December 2017 with series so. Mr. M. Izzat, sitting MDC from 20 DCC Pungia, was elected uncontested as Vice Chairman. He was proposed by the executive member BL Lordship. This is the latter, Lordship, the communicating about the election of the
Election
president
of the
appellant
Vice Chairman.
as a
Yes.
Vice Chairman, Lordship.
Yes.
This I have taken a statement in my writ petition, Lordship. May I take my lord to page number 89?
Just,
Page number 89, Lordship.
yes.
Para 10. The following the constitution of new autonomous district council in accordance with the provisions of section 4 of the Manipur District Council Act 1971. Series was elected as chairman. Subsequently, President petitioner was also elected as vice chairman of Ukhrul Autonomous District Council Ukhrul, which can be substantiated from the letter dated 21/12/2017 of the CEO Autonomous District Council Ukhrul. Thereafter, the Ukhrul Autonomous District Council Ukhrul has started its function and carry out its public duty as required and expected from such an institution. This paragraph, Lordship, is not controverted by the state government in their counter affidavit.
Let's see the affidavit.
May I take multiple page 162?
Yes. Para 5.
Yes. Para 4. That refers to para 10 of the writ petition. The answering deponent has no comment to offer.
Just.
And again, respondent number 4.
Just.
Yes.
You refer page
The respondent number 4, also in his counter affidavit, has not disputed. Page 169. Paragraph number 5, my lord. That in reply to the contents of para number 10, 11, 12, 13, 14, and 15 writ petition, the answering respondent has nothing to say, my lord. And the Lordship, of course, this certificate was not before a single judge. But Lordship, I am filing one certificate, Lordship. May I take my lord to page number 68?
Yes.
68. This is certificate, Lordship, certifying the election of the present appellant as the vice chairman. In other words, Lordship, the only party to the proceeding has not controverted, disputed the position of the present appellant that he was functioning as a vice chairman of the ADC. And the Lordship, may kindly appreciate the Lordship. The life of the ADC in Manipur expired in 2020, Lordship. Under section 13, Lordship, it can be extended by 1 year, Lordship. State government, however, extended only 6 months.
Okay.
After 6 months, Lordship, application was submitted by the ADC members and chairman to the authority that the term may be extended till election is held. Instead of consideration, Lordship, what they have done, Lordship, on 13th November 2020, in exercise of power under section 47, supersession of the only ADC in Manipur, Lordship, was issued. That was challenged in 3 writ petition, Lordship.
Yes.
In 3 writ petition, Lordship, was heard, and the Lordship, an interim order was passed by the Honorable Court, extending the term of
the ADC.
ADC.
Okay.
And that was finally disposed of by the Honorable Court, Lordship, on 2nd March 2021. Lordship.
Just.
Yes, may I thank my lord too?
Please,
Yes, the judgment,
please tell us the date of order of
supersession,
supersession is
13th November 2020.
13th November
Yes,
20.
yes.
Yes.
That order lordship find at page 109.
Okay, then writ petition, which writ
Writ
petition
petition,
was?
lordship, third writ petition, lordship, WPC number 613/2020. And the WPC number 645 of 2020. And the lordship, WPC number 647 of 2020.
Okay, what
And
was
the
the order
lordship-
in that?
May I take my lord to paragraph number 4? This is the common judgment in the order,
Page.
page 118. That on 27 November 2020, when the writ petition
Please,
came out
please,
for
please,
consideration.
please wait for a while.
I'm sorry, ma'am. I'm sorry. Page 118,
The orders start at page number
right,
110.
yes. But I'm taking lordship to the relevant portion to, to continue number court that when all this writ petition was taken up by the learned single judge
Mhm.
of the High Court of Manipur,
Mhm.
an interim order was passed on 27/11/2020.
You are
On
referring to,
27/11/2020, when the writ petition came up for consideration,
Mm,
this court filed issuing notice to the respondent, passed an interim order directing that term the district council in respect of the hill area be extended till 4/12/2020, for which the state government should issue necessary order. Lordship. Then the lordship in the body of the judgment, lordship learned single judge after discussing various provisions of the act and by referring to the various decisions, the lordship
mm.
makes certain observation, lordship, at para number 16, page 138. I'm not reading the whole paragraph. May I just take a lordship to page 140? About 5 lines from bottom, my lord.
140.
5 lines from bottom, page 140.
Yes.
On top of that, it may be noted that 27/11/2020, when the writ petition being shown as show came up for consideration, this court passed an interim order directing that term of the district council be extended till 4/12/2020, and that a necessary order should be issued. Accordingly, instead of issuing any order extending the term till 4/12/2020, the interim order was issued superseding the district council. This is contrary to the interim order dated 27/11/2020 passed by this court. In other words, the interim order which has violated the interim order of this court is bad in law and it being unsustainable and liable to be quashed and set aside. No method has been placed on record by the state government with interim order that has been quashed and set aside by an appellate forum. Also, rightly learned single judge passed the order. Was the order, because lordship, any order passed in violation of any order, judicial order, either interim final order, it is a nullity in the eyes of law. That is a settled position of law. Then lordship, the writ petition was disposed on finally in terms of the order at para number 17. May I read again?
Yes.
I read it earlier, but I read again. Lordship. For the reasons stated herein above, writ petition being shown as such stand disposed of with the observation made herein above. So I allowed and consequently the interim order that was set aside with the following direction. State government and in particular the additional chief secretary of the government of Manipur shall write a letter to the Hill Area Committee Manipur, legislative assembly seeking its opinion as to whether the term of the district council shall be extended or not till the completion of the election. The said letter shall be written within a week from that we receive the copy of this judgment order. On receipt of such a letter from the additional chief secretary, government of Manipur, the Hill Area Committee Manipur Legislative Assembly shall furnish the opening within a week from that we receive the letter. After the opening of the Hill Area Committee, Manipur Legislative Assembly being duly received, that government shall take a decision, issue an appropriate order immediately in terms thereof. Till such an order is issued by the state government, as mentioned in direction C, above the interim order that has one so passed by this court shall continue. Lordship. State Election Commission is directed to announce the so. Lordship, after this judgment, writ appeal has been filed by the state government.
Writ appeal filed when there is no stay.
No stay, Lordship. And in the writ appeal, Lordship, the learned advocate general appearing for the stay, way back in 2022, made a submission before the court that cabinet has taken a decision for holding the election, and he may be given time to place on record. That has never been done as on today, Lordship,
Okay.
as on today.
Mhm.
And the Lordship, instead of.
Do you have any proceedings wherein this submission of the AG has been recorded?
No,
No.
no.
Okay.
And the Lordship, what happened, Lordship? Contrary to the order passed by the Honorable Court, Lordship,
Mm.
in 2021, on 17 May, Lordship, not on the recommendation of Hill Area Committee,
Mm.
as directed by the Honorable Court, Lordship.
Mm.
Lordship, there was a COVID period. What happened, Lordship, on the recommendation of State Executive Committee, Relief in the Disaster Management Department,
Mm.
Lordship. Only the chairman, ADC, was allowed to function as caretaker. chairman,
Caretaker.
Lordship. That was on 17 May 2021. And the Lordship, that was again rolled back. That was again rolled back on 27 June 2022. No, I'm sorry. Or 4th August 2022, my lord. Page 146, that was rolled.
Just.
And the Lordship, that was subject matter of repetition.
Just a moment.
Yes. 4th August 2022.
At page number?
Page 146, my lord. That was rolled back. That was subject matter of writ petition, Lordship. And all those writ petition was heard together along with writ petition filed by municipality, Lordship. Manipur municipality. In municipality also, there is no election, my lord. And the Lordship, may I take my lord to?
The order is dated 4th August. Yes.
4th 4 August.
So the caretaker chairman system was discontinued.
Discontinued.
What would be the outcome? What would be the function? How the autonomous councils would function?
They have not
Gray
any
area.
kind of arrangement thereafter.
No.
Lordship, we challenge it. One, the Lordship, it is subject matter of 2 writ petition, Lordship.
Mm.
May I take my lord to para number 13 of the.
With writ petition number, your writ petition is number?
Yes, writ petition number, Lordship, 632 and the 633 of 2022. This 2 writ petition was heard together with other
The
writ petitions
municipalities.
filed by other urban body,
Okay.
where election is not held in spite of the expiry of the period, Lordship.
Mm.
And the para 13, Lordship, may I read?
Para 13?
13, page 155.
Yes.
Therefore, I'm inclined to grant the interim order already granted in so and so.
Mm.
The according to interim order dated 4/I/2022 are stay, Lordship.
Okay.
And the Lordship, in the operative portion of the order, what the London single judge says, the Lordship.
Just.
Right. Good.
Can go a little slowly.
Yeah.
You have a flight to catch.
I'm sorry.
Do you have a flight to catch?
No, I'm sorry. I'm sorry.
You're taking things by hand.
No, I'm sorry. Lordship,
We
Lordship
try to
hurt
move.
last time.
We
Lordship-
try to move fast. That's right. But
Lordship hurt me last time. And the Lordship was making query from London as AAC.
yes.
About what kind of action has been taken by the state government as regards to A and the B and the C of the
Let's
judgment.
read now.
Right, my lord.
Yes.
And the Lordship at para number 14,
Mm.
what the court says, the Lordship, till the election of these democratic institutions notified, they be allowed to continue.
Mm.
That is the order, my lord, in
Mm.
short. And the Lordship, this order is complied with by the state government on 14 March 2023.
Mm.
Next phase.
So by this, the caretaker system was revived.
Revived by
Mm.
this order dated 14 March 2023. And the Lordship,
Mm.
by an order dated 27 March 2023,
Mm.
Lordship. In Ukhrul district, Lordship, the then chairman have tendered their resignation, his resignation.
Yes. Okay.
Because of that, Lordship, the vice chairman, Lordship.
He claims the right
Lordship,
to
I'm
be.
coming to that.
Mm.
On 27 March 2023,
Mm.
instead of consideration of the vice chairman to function as caretaker chairman, a member of the then ADC
Mm.
has been appointed as caretaker chairman.
Mm.
That is order dated 27 March 2023. This order was intended before a London single judge.
Yes.
Lordship will find that last paragraph number 5, page 158.
Yeah, we have read that. Yes.
Yes, whereas in continuation, the government order dated 14 March 2023 The government of Manipur is pleased to allow Sri Mark Lieutenant, member of the last constituted ADC Okur, to function as caretaker chairman ADC Okur till the issuance of notification for the election of ADC Manipur. Lordship, this order having been issued in continuation to order dated 14 March 2023, Lordship, it is Lordship compliance of the order passed by the Honorable Court. But Lordship, this situation is this Mark Lieutenant was not functioning as a caretaker chairman of the ADC Okur. He was just an ordinary member of the then ADC. Which the challenge is, Lordship, on the ground, and Lordship, this violates Rule 9 of the ADC.
Okay.
Where it says, Lordship, whenever chairman is not there, Lordship, the vice chairman has to take over the responsibility of the chairman. He has to act as the chairman.
Yes.
Number one. Number two, Lordship, in the ADC Act and the rule, there is a provision vesting the state government to appoint a person of this choice, Lordship. Number three, Lordship, it is a pick and choose. Number four, Lordship, it is a democratic institution, Lordship. In a democratic institution, Lordship, it is unheard that the government appoint a caretaker chairperson, Lordship, which is not provided anywhere under any law, particularly ADC Act and the rule, Lordship.
Okay.
Learned single bill, Lordship, when it was taken up, was pleased to pass an interim order, and a detailed interim order was passed at page number 69, my lord. Page number 69.
What is the date?
That is Lordship 3rd April 2023. Yes, page 69.
Yes.
Lordship,
see.
I read from paragraph number 4. Considering the cases, this court granted interim order. Matter was taken up along with the other cases, so on and so, so on and so. I'm not sorry, yes. Yes. Considering the cases of the public petition, the order that is on and so passed by this court, please read as a follows. Present writ petition are disposed of, the interim order granted as on and so. This is regarding the revival of the acting chairman. There are 6 Lordship. Pursuant to the order dated 19/1/2023, government also passed an order on 14/3/2023 admitting the person who are functioning as caretaker chairman and the members directed to continue till the issuance of notice of the election ADC Manipur. Therefore, he further states that present impleadment order has been passed by the Deputy Secretary, Government of Manipur, by one Mark Lieutenant has been appointed and allowed to function as caretaker chairman. ADC Ukro. The said order dated 27/3/2022 has been challenged by the state petition. Since the order was passed against rule number 9 of the Manipur Hillier District Council Rule 1972, which states as follows. Rule 9, order by chairman or other person to perform duties of the office or for to act as chairman. While the officer's chairman is vacated, duties of the officer shall be performed by the vice chairman. During the absence of the chairman from any meeting of the council, the vice chairman, or if he is also absent, one of the deputy chairman shall act as chairman in accordance with the provision of Rule 5. Then Lordship, there are 7, 5, 7 Lordship.
Yes.
There are items of government stand. There is honor so with tax notice of the written 1 to 3 represented.
So, all right, that order has been stayed, it's an interim order, plain and
And
simple.
the Lordship, in interim order, the learned single judge was of the view that Rule 9 is.
That is an interim order. It doesn't have any precedence.
Right.
Value.
And the Lordship, in the impleadment order, learned single judge said, the Lordship, since the term has expired, Rule 9 is not
applicable. No, that's
and therefore government exercise its discretion.
Yes, that is the question which really crops up in the mind, whether the government has any power,
Right.
whether this aspect has been dealt with, that the government has a power to appoint
Right.
the caretaker. How this aspect has been dealt with in the single bench order?
In the single bench order, Lordship, the order of the judgment was referred to, but the part pertaining to making the ADC alive, it is not discussed, madam. May I take my lord to impleadment judgment? Yes, Karen. Yeah, Karen. Yes. Yes, Lordship, started from page 41, and the Lordship learned single judge have referred to the order, Lordship. May I take my lord to there are 19 pa- Yes. Paragraph, Lordship, is discussed from
Come to para 17,
para 19, Lordship.
para 17 first,
Para
para
16
16,
19, my lord.
para 16.
Yes, para
Hmm.
16.
Hmm.
Lordship, it is not true that the only method of appointment to the post of chairman of the Autonomous District Council is by election in accordance with the provision of Manipur Hill Area Jurisdiction.
Hmm.
Lordship, for the election of chairman, it is done by the state government. But for the election of the vice chairman, it is done by the council itself.
Yes.
That is the only difference, Lordship.
Election of the chairperson is by the government.
By the state government.
Appointment, okay.
Yes, notice has to be. And in respect of the vice chairman, it is done by the council.
What is the process of appointing? How is that process?
Lordship, the election is held.
No,
and
no,
once
of
he
the
is elected-
chairman.
Chairman. Lordship, he is elected, he becomes chairman.
Elected by whom?
Elected by the Lordship, by the member of the council, Lord. There are 24 members.
So the result of the election is conveyed to the government. And then the government appoints.
Since if the election is held by the state government, Lordship, then it is to be published by the state government. And in the case
How,
of
we are trying to understand.
Yes.
How would the state government step in and hold the elections?
Lordship, it is under the rule.
Let's see.
Rule 9.
Let's see.
May I take again to rule 9?
Yes, please.
Rule 9, Lordship, will find at page number. I have reproduced it in the memo appeal also. May I take my lord to page number 14.
1-4.
1-4. Memo appeal. It is in the judgment also, but for reference, Lordship. I'm supplying the rules also, my lord. But may I read? Election of chairman by council. The election of chairman shall be held on such that as the governor may fix, the secretary shall send every member notice to this death. Before the election of chairman, the governor shall appoint a member of the council who does not intend to contest the election to preside at the meeting. Rule 4 of the so deals with the election of chairman by council, which is reproduced as under. Election of vice chairman by council. The election of vice chairman shall be held on such that as chairman may fix, the secretary shall send to every member notice of this death, my lord. So, Lordship, that is why at page number 107, after election of the present appellant, election of the present appellant having been appointed after election was communicated with the government. Right, then that is the procedure adopted. So far, it is concerned.
So you were saying, Mr. Counsel,
Yes.
that the election of the chairman is done by the government.
Yes.
Where does the provision say so?
Lordship, merit.
So the governor appoints a member of the council as a provisional chairman
Right.
to conduct the elections.
To conduct.
Oh, that's
But
all
every notification is issued by the state
issued by the government.
government. That is a difference.
All right.
In respect of the vice chairperson, Lordship,
There is no
it is
provision
done by
for,
the chairman.
all right.
Chairman. And the Lordship, at para number 17 of the judgment, which the Lordship's query from me, how the learned single judge
Yes.
deal with this, my lord.
Paras-
May I read, my lord, the paragraph number 19,
Sure.
55. Aggrieved by the issuance of the order that the 30/11/2020, that is supersession order, a batch of petitions so and so came to be filed before this court. This court, by the order dated, so and so disposed of the writ petition with direction. The opportunity to order read thus, para 17 is reproduced, which I just read. Then in compliance of the order dated 17/5/2021, the relationship secretary had passed an order appointing all the existing chairmen of the Autonomous District Council to serve as caretaker chairman for smooth functioning of the administration of the ADC till the election of Autonomous District Council are held. Accordingly, respective former chairman of Autonomous District Council, including Autonomous District Council, will continue in the respective capacity in the functional activities are carried out, including the deputy work. Also, the former chairman of the Autonomous District Council has tendered his resignation by so and so, to demit the office so and so. Thereafter, pursuant to the decision of the cabinet dated 27/7/2022, the order dated 17/5/2022 by allowing the former chairman to function caretaker chairman stands cancelled by order dated 4/I/2022. Resultantly, the caretaker chairman system under ADC Manipur discontinued with immediate effect. Agreed by the order dated so and so, a batch of petition can be filed. This court by the order dated 19/1/2023 dispose of the said petition into portion of the order. It does. I'm not reading again. On provision or perusal of the provision of section 23(1) of the Manipur Hill Area District Council 1971, it is in that when the officer of chairman and vice chairman become vacant, the elected member of the said council to have choose another member of the respective autonomous district council as chairman by holding an election by issuing appropriate notification by the concerned deputy commissioner. A stated supra, Rule 9 contemplates the manner if the official chairman is lying vacant. The vice chairman has to perform the duty of the official chairman of such council. However, it is said that Lada government advocated that Rule 9 will be affected while the autonomous district council was in existence. But in the instant case, as the term of the ADC has already expired in the month of June 2020, after expiry of the extension period, the petitioner is no longer holding the post of vice chairman, and therefore he cannot set the act of Rule number 9.
All right, we have gone through the order. Okay.
And the lordship, what then the learned single judge proceeded, the lordship. The appointment of the president resolution number 4, lordship, by the state government is as part of the policy decision.
Policy decision.
That is what is
That's what we have, yes, we have noted that.
Yeah, number
What
26,
policy?
number
Which
20
policy?
Yes, state policy.
Which policy?
I know not indicated anywhere. Lordship, may I read, para 26.
Yes.
The chairman of the elected member of the Autonomous District Council of Manipur up to 17/6/2020. And in terms of the provision, the elected member terms have been extended for a period of 1 year. So on, thereafter, they are no longer elected member of the Autonomous District Council. Hence, in terms of the state policy and in compliance with the order passed by this court, in various writ petitions, the government issued the order dated 27/3/2023. Allowing the private respondent return to function as caretaker chairman under the Autonomous District Council to fulfill notification of the Autonomous District Council so. Lordship. And the lordship, what is that government say in the counter affidavit? They say this something. They say the lordship, the order is issued in compliance with the honorable court's order. And as the lordship is saying that order dated 27 March, it is in the continuation of order dated 14 March. Lordship. Now, lordship, whether this Mark Litang was a caretaker chairman at the point of time, no, it was merely a member. Lordship, Learned Single Judge ultimately come to the conclusion that lordship, at paragraph number
29.
yes, 29. I have read it, lordship. So, lordship, Rule 9 will be into play only when life of the ADC is alive. Question comes up, lordship have seen it. That particular paragraph number 4 and other paragraph where the Learned Single Judge indicated about the continuance of the ADC because of the interim order until the decision is taken in terms of the order, lordship. It is not dealt with by the Learned Single Judge. This has the lordship, ADC term is over, meaning thereby, lordship, he ignored the judgment of a coordinate bench, which is operating in the field. And the lordship held that this order, lordship, what he says, last paragraph, paragraph number 31. It is the absolute view of this court that order dated 27/3/2023, appointing the fourth respondent as caretaker chairman of the council was issued by the government of Manipur by exercising its power for administrative convenience.
Is not required to interfere by this.
Administrative convenience, which is not required to interfere by this. That is the conclusion arrived at. Learned Single Judge held that this is an order for administrative exigency. Lordship may kindly appreciate it. ADC is a democratic institution. It has act and the rule.
Yes.
And the lordship, the act and the rule nowhere vested is the government any power to issue except the power of supersession and the power of the extension of the term. That also 1 year. Supersession is also limited period, 1 year maximum, extendable by another 6 months under section 47. This is the only power vested with the state government. And the Lord said, why the rules are there in fill? Why these rules have been ignored by the state government? Why it hasn't been ignored by the learned single judge, number one. Number two, Lordship, it is a democratic institution, Lordship. In democratic institution, till a new election is held, Lordship, the incumbent continue. If the chairman tender resignation, that is not disputed fact.
Yes.
If some caretaker chairman is there, Lordship, is required to be appointed. Find out the present appellant who was legitimately vice chairman. Why a member, ordinary member of the last concluded ADC chairman? Why it was done in such a big and assumed manner, Lordship? And the democratic norms in the practice have been violated, and the rule has been flouted. Even the order of the court, which is now under appeal, has been flouted, Lordship.
No, that is under appeal, but there is no interference.
No interference. And then Lordship, the set of the order passed in the eighth appeal, Lordship. I'm submitting, Lordship,
What order?
in the eighth appeal.
That has been decided.
No, not decided, it is continuing. It is coming up on Lordship again on 15th.
Okay.
And there's no stay order. Lordship, as early as on 26 July 2022, Lordship, at the Advocate General made a submission before the Honorable Court that Leninism learned Advocate General appearing for the statement from this court that a cabinet decision was taken in relation to the election of ADC, neither to be adopted in the interregnum. He seeks time to file a copy of the order passed pursuant to the said cabinet decision. No copy, no paper is placed in the, and the Lordship, any decision of the state government was enclosed in the counter affidavit filed by the state government in the present case also, as the Lordship is saying it. It is a very small paragraph. Very small counter affidavit filed by the state government. I take a Lordship again to page 162. That is a small paragraph, very small affidavit. It started from page 159, and the Lordship, the only same thing, Lordship. And what they say in para number 10 and the para number 12. With reference to para 23, so the answering department back to submit that though the district council rule does not provide for constitution of caretaker chairman under ADC, the government by so appointed the last constituted chairman ADC as caretaker chairman in compliance with the honorable court's order that is so. Then para 30, with reference to para 26,
So you are trying to highlight that there is nothing in the affidavit regarding the proposed plan for elections.
Nothing, Lordship, nothing. And in my writ petition before the court, Lordship, in the other writ petition where the court passed order, prayer was, Lordship, to conduct election. Where the Lordship, the last order was passed, which was complied with by the state government on 14 March. The prayer in the two writ petition was for holding election, Lordship. Which they differ from time to time for some reason, which is explained as on today, my lord. This is a case, Lordship, where Lordship, the rule, judicial order, and the practice in the procedure governing the democratic institution, Lordship, has been grossly violated, madam. Flouted.
Let us hear the other side, then you'll have a chance. Yes. Mr. Advocate General, you are the Advocate General?
I'm additional.
Additional Advocate General. First, we'll like to ask you regarding what is the stand of the government regarding this order dated 26/7/22? What has been done thereafter, which was referred to in writ appeal number 20/21?
Yes, my lord.
Yes.
So, my lord, we.
What is your statement in the affidavit? Affidavit was filed in May 23.
May 23 of.
In this in the present writ petition.
In this present writ petition, my lord, we have stated that.
Yes. What is your stand about the elections?
Election, because the cabinet has already approved for holding the election in the month of October 2022, my lord.
Where is that decision, gentlemen?
That's what I just want to say.
Why was it not filed in the writ proceedings? And if it was done, it was to be done in October 22, as you say.
Yes, my lord.
Why was this not brought on record?
My lord, in this writ petition, is not challenging.
We are asking you a simple question, please. Why was it not brought on record?
In the writ petition.
Yes,
writ appeal, my
that
lord.
is their prayer.
In the.
Let us see the prayer in the writ.
That's what my lord.
Yes.
My lord, that's what my lord is asking some other question because it is not related with the election, my lord.
Let's see.
Yes, my lord.
Prayer,
Prayer,
Mr. Council, prayer at page number.
102, my lord.
Yes. And there need not be a prayer. There's already a direction
Yes. it's
by
only
the court.
direction. It's only the direction, my lord. Kindly
There
see-
is already a direction, sir.
Yes.
Yes,
Issue 103, my lord. Roman.
yes.
Issue a written substitute or any other rate or direction in order for passing and setting aside the impingement, allowing the private respondent to function as a caretaker chairman under the autonomous district council rule as not sustainable in the eyes of law. 3, issue a written.
So there is no prayer, we assume,
Yes.
but all the same,
Yes, my lord.
why are you hiding these proceedings? Have you filed this in that writ appeal?
Because in the writ appeal, my lord, we are challenging that. In the writ appeal, why we are challenging is that, my lord, there are only 2 issues has been framed for deciding the writ petition, my lord. My lord, I may be allowed to take.
All right.
My lord, case number. Case number 109, my lord. Para number 10, my lord.
Yes, please. 109.
109 is a judgment, my lord. Then I'm taking to the operative part. Page number 126.
You are reading the judgment in the earlier round of litigation.
Yes.
Yes, read.
My lord, I'm taking to the straight away to para 10, 126.
Yes, please.
Learned single judge framed 2 issues, my lord.
We are not examining the validity of that judgment.
No, my lord. Because of that judgment only, this all order has come up, my lord.
Yes.
Because in this order, the learned single judge framed 2 issues, my lord.
Yes.
Page para 10. A, whether the policy decision taken by the state cabinet on 10/11/2020 and letter dated 13/11/2020, written person by the Joint Secretary TN Hills Government Manipur to the State Election Commission to take necessary actions are legally valid, my lord.
Yes.
B, my lord, kindly. Whether having regard to the fact and circumstances of present case, the state government is justified in exercising its power conferred by section 47 of the Act 1971 to supersede the district council. So far, this issue number 1, learned single judge has not decided because it becomes infructuous, my lord. During the pendency, because term has been expired.
Yes.
And B, because yes, the administration has no power by superseding the district council.
Yes.
So what I'm coming before this court is that, my lord, coming to section 13, the term of the office of the member, my lord. Section 13. My lord, I've got the act, my lord.
Yes, we have got that.
Act. Section 13. Except as otherwise provided in the section, the term of office of the member shall be 5 years, my lord.
Yes.
And shall commence from the date of the notification of his election or nomination under section 12 from the date on which the vacancy in which he is elected or nominated has occurred, whichever date is later, my lord. Provided that administrator may, when satisfied it is necessary in order to avoid administrative difficulty, my lord, kindly note, extend the term of the office of all members by such but not exceeding 1 year as it thinks to. Only 1 year has been allowed. And then coming to 2, my lord. The term of office of a member elected to fill a casual vacancy shall commence from the date of the notification of his election and shall continue so long only as a member in whose place his election would have been entitled to hold office if the vacancy had not occurred. My lord, what I want to say is that, my lord, my petitioner council has submitted that this vice chairman has been elected at the petitioner, my lord. What I'm coming is that, my lord, before in the year 2015, there was one vice chairman, my lord, elected by the committee, my lord. Then subsequently, he was resigned, my lord.
Not vice chairman.
What are you trying to bring on record?
No, that vice chairman has been.
Not vice chairman.
No, vice chairman has been resigned.
These are documents not on record, Mr. Council.
Yes, my lord, I just want to highlight because this has to be brought.
What do we have to do about the proceedings which took place in the earlier council?
No, at the time of the hearing, we produced this order, my.
No.
Yes, we produced this order. This is 11 December 2017, my lord.
When was the present council constituted? What is the date?
Present
council elected.
This is, my lord, what I'm is saying that the present petitioner who is claiming that he's a vice chairman,
Hmm.
he never been the vice chairman in the Ukul district.
That is not your denial in the writ petition. You have not denied that fact.
But
So what you are arguing is contrary to your pleadings.
But the learned signature at the time of hearing, we produced this order and it was recorded, my lord. Kindly come to that, this letter, my lord.
Yes.
I just want to apply. This was issued on 11 December 2017, my lord.
Hmm.
Whereas the chief executive officer, this is issued by the Secretary of Tribal Affairs and Hills, Manipur, my lord.
Hmm.
Whereas chief executive officer Ukul Autonomous District Council, Whitehall letter number so on 12 October 2017 reported that CKI Thanmi, Vice Chairman Ukul ADC, tender his resignation from the office of the Vice Chairman Ukul
Yes.
ADC. Under the provision of Rule 8B of the Manipur Hill Area District Council Rule 1972, White his letter dated 9 October 2017, addressed to Chairman Ukul ADC and delivered to the CEO of Ukul ADC on the same day. Now, therefore, the governor of Manipur is pleased to notify that the office of the Chairman Ukul ADC has fallen vacant with effect from 9 October.
Yes.
Kindly note this, my lord.
Hmm.
Then, my lord, I am coming to the what my colleague has been relying, the certificate issued by the returning officer.
Hmm.
This was not placed in there at the time of the writ petition, my lord.
Yes, it is filed with appeal.
Yes, my lord.
Hmm.
This page number 68, my lord.
Yes.
Very interesting. This order was acceptance was vacant fallen on 11 December 2017, my lord. And this certificate was issued on 28 December 2017.
Yes.
After 8 days, my lord.
Hmm.
It is not possible also, my lord. Because as per the rule and act, it has to be notified by for the election of the, again for the vice chairman,
Hmm.
as per the section 3 and section 4, my lord.
Hmm.
So this is, my lord, kindly note this, 20th December.
Are we looking at the validity of those proceedings which were not disputed? Are we examining the validity of those proceedings which were not disputed by you in the writ court, sir?
But
You had an opportunity to controvert that fact.
what we are.
What was your pleading? Let us see in the writ court. Read. Read his submission, government, and your reply.
Yes, yes, my lord.
Yes.
Page number 162.
Yes.
Yes,
Read,
my lord.
please.
My lord, coming to this, this is my reply. Let me take to the writ petitions, my lord.
Yes.
Page
Read his
number-
pleading first. Read his pleading first.
Yes, my lord.
Then read your affidavit.
Yes, page number 89, para
Yes.
10.
Yes.
That
Read.
the following constitution of the new autonomous district council in accordance with the provision of section 4 of the Manipur Area District Council Act 1971, one Sri Dr. Yonason Ganglo from Rinkui village of the Ukul Autonomous District Council, Ukul was elected as its chairman. Subsequently, present petitioner was also elected vice chairman of the Ukul Autonomous District Council, Ukul, which can be substituted from the letter dated 21/12/2017, my lord, of the
Yes.
Chief Executive Officer, Autonomous District Council, Ukul. Therefore, Ukul Autonomous District Council has stated its function to carry out its public duty as required and expected from such an institution, my lord.
Hmm.
This is the only letter, 21/12/2000. We have not controverted the letter, my lord. We have not controverted the letter, my lord. Why I want to say that, my lord? So far is coming to the section 12, my lord. Section 12 saying that once it is result is declared or who has been elected, my lord, that has to be notified in the gazette notification.
That is for the chairman, as was argued.
No, my lord. Section
That was the argument, because election of a vice chairman is an internal affair of the council, whereas the chairman is appointed by the order of the governor.
Then why this order?
Read the provision.
My lord, yes.
Read the
Section-
provision.
Section 12, my lord.
Yes.
Notification of result of election, my lord.
Let's see. Wait, just hold on.
Yes,
You're
section
reading section?
12, my lord.
Yes. Section 12. Hmm. So that is the notification pertaining to election of the council and its members.
Yes, my lord.
Thereafter, the election of chairman and
Vice chairman.
vice chairman.
Yes.
How is it to be done?
Yes.
Let's see. Where is the requirement of notification?
Yes, section 12, my lord. Notification of
12 is of the all persons
of
elected.
all the
That
members.
was in 2015,
Yes,
whether it was done or not.
it was done.
Then
Then
that
it was
part is
done.
over.
That part is over now.
Yes.
And coming to the chairman and vice chairman, as
Yes.
per the rule, my lord.
Section 9.
Section 9 is for the power of duty, my lord.
Rule 9.
Rule 3, my lord.
Yeah, rule 3.
Yes.
Rule 3 is at page.
Is the page number 2, my lord. Conduct of business, my lord.
Thank you.
Read.
Part 2, conduct of business, chapter 1, chairman and vice chairman. Election of chairman by council, my lord. The election of a chairman shall be held on such that as the governor may fix and the secretary shall send to every notice of this death, my lord. B, before the election of the chairman, the governor shall appoint a member of the council who does not intend to contest the election to preside at the meeting, my lord. 4, election of vice chairman by council.
Yes.
The election of vice chairman shall be held on such that as the chairman may fix, my lord, and the secretary shall send to every member notice of this death, my lord. This was never
We
done.
are not bothered about it, sir. That is not the question in the writ court. There is a certificate of the election officer. That is not an issue to be decided.
No, that.
You did not controvert it, sir.
My
Now
lord.
you are not entitled to say this in the writ appeal. Plain and simple. Facts which are not pleaded in the writ court, they cannot be allowed to be argued in contrary to what was the period before this writ court. We will not allow that. You just read the provision that the election of the vice chairman is required to be notified by the government.
Yes.
Read.
No, I'm reading, conjoined with this, rule 4 and as well as section.
You
12.
argued, Mr. AAG, that the election of the vice chairman is also required to be notified.
Yes.
Where is that requirement?
It is not mentioned, my lord.
So it is not mentioned. We presume that there is no such requirement.
But we have taken the principle of the act, my lord.
Ah.
Because so far as one has been elected, at least it has to be notified. Because the state.
We don't know. There is a distinction carved out in the act and the rules.
Then-
What is required to be notified is mentioned in the rules.
Then, my lord, why this resignation and this has been accepted by the government? The government has issued this 11 December 2017, my
Yes,
lord.
you may have done it.
Yes, my
May
lord.
have- without there being a requirement. Governments do many things. That is why the writ courts are called
When
into
the
action.
rule and act is silent, my lord, we have to borrow something, my lord.
All right.
Then, my lord, coming to rule 9,
Yes.
it says the power of vice chairman, my lord, power of vice chairman or, my lord, or is there, my lord, or other person to perform the duties of office
Yes.
or to act as a chairman, my lord. The power is not only given to the vice chairman, the power.
Where is the
given to
power given to the state to meddle into the affairs of a democratic body like the Autonomous
Once it
Council?
is expired.
Yes, so only read the act that the state has the power to appoint an administrator. Read the provisions.
My lord, in the provision, my lord, in the act and rule, when the rule is silent about the extension after 1 year, the government has a full discretion, my lord. My lord, we are coming to the
From the act,
policy.
gentlemen.
We have to make some policy.
So where is the policy?
That's what, my lord, we have placed the thing, my lord, that
Oh, wonderful. Which policy, please?
we have cabinet decision has been taken, my lord.
Yes, when? Yes.
My lord, in the second phase, where this is a memorandum for the cabinet, my lord,
Yes.
and this is on 1st August 2020, my lord.
Yes. What is the decision? Let's see.
Decision.
That will take over the ADCs.
Yes,
Yeah, all right.
we have
Let's see.
taken the decision in the first phase,
Let's read.
ADC election schedule and ADC amendment bill.
Yes.
One approved to schedule the ADC election in the month of October 2022. Roman to approve to refer the draft bill to the Hill Area Committee for soliciting its views thereon, my lord. This was a decision taken by the cabinet, my lord.
Yes. Approval for introduction.
Yes,
Till now, there is nothing on in black and white.
yes, my lord. Why
Whether it has been introduced.
bill has been introduced, my lord?
All right. Let us see where is the bill.
Bill
What is the fate of the bill?
bill, my lord, it is in the money bill, my lord. And we have not brought that copy, my lord.
You have not brought that, it
Yes,
is
my lord, because
virtually non-existent.
because it is not, what, no, yes, my conviction may be right or wrong, my lord. My submission before this court is that
Yes, please.
whether the common judgment passed by the learned single judge
Mm.
will bind to the all the subsequent cases or not, my lord. Because it is a per inquiry, my lord. Because
Learned single judge says,
learned single judge.
you have the opportunity, Mr. Double AG, to get the correctness of that view examined before the division bench. Why are you not doing it?
That's what, my lord.
There's no stay.
No, we are doing it, my lord.
There's no stay, gentlemen. Why didn't you get an interim order?
Matter is coming on field, you'll be deciding it, my lord.
All right, let it be decided.
It's going to be decided, my lord.
Yes.
And why I want.
Till
to
it is
say-
decided, Mr.
No,
Mr. Double AG.
But
The direction is,
whether, my lord, this learned single judge, common judgment will be binding to this court or not, my lord, that has to be examined.
yes, very well.
Yes, my lord.
Yes.
That's what I'm citing it. Because
It is
has not
binding
had-
on the
it has not
facts.
given any reason for the, this section 13 for extension of the 1 year or giving to the power to the vice chairman who has already expired a term.
So what about the person you have picked out? Whether he is a member now? You have appointed him as a member. Does he continue to be the member after the term has expired?
The term is expired, he is not a
Then-
member.
then
Everyone is not a member.
You brand him to be a member in your order. On what basis?
Because.
What gives you the discretion? All right, simple question. What gives you the discretion to select him? Come out with that. Okay. Even in your policy decision that we have a right to select any Tom, Dick and Harry for that matter.
No, my lord, the learned single judge given a direction in this case number 95 and others saying that the last constituted from the autonomous district council's member can be appointed as a caretaker, my lord.
Yes.
That's what, my lord. So what I want to say is that once term is expired, my lord, once
Yes.
the term is expired under the section.
Term is expired so far as the so-called vice chairman is concerned, but the member still continues to be the member.
But
That's what you want this court to
common
believe.
policy, my lord, government has to be.
Which policy that we have a power to appoint any person as a caretaker? Which is the policy decision? Show us.
But for this smooth functioning, my lord,
There is an indication given in the act that supposing the chairman is not available, you give the power to the vice chairman. Why not follow that? Particularly when you have not disputed the election of this person, this appellant.
yes.
So why not act as per the rules? Have you put the rules under supersession?
No, my contention is that once the term is expired,
Let us see the appointment order then. Let's see the appointment order.
Yes, my lord.
Yes.
This.
Where is the appointment order at page number?
157, my lord.
Yes, let's see that.
This was never challenged, this 14
Just
March.
hold on.
My lord, let me come to first page number 157.
Yes,
After this, only this appointment has come up.
yes.
This 157 order has never been challenged by any of the persons, my lord. My lord.
Yes, let's see.
This para number 3, my lord.
Hmm.
In view of the above, the Honorable Governor of Manipur is pleased to allow the last constituted caretaker, Chairman of Autonomous District Council concerned to function as a caretaker chairman till the issuance of notification for the election of.
They were not aggrieved of that because the chairman was there. Under the rules, the chairman was allowed to function. All right.
Yes,
We are asking you appointment of this respondent, private respondent.
yes, my
Which
lord.
is that order?
Yeah, next page, my lord.
Yes. That order is under challenge, we presume.
Yes, this order
Yes.
was challenged, but this order was never.
You referred,
In
which
term-
order?
In terms of this para 3, we have appointed this private respondent number 4.
What gives you that discretion? We are asking you. You can pick and choose anyone. You refer to him as a member of the last constituted ADC, then why not the vice chairman? Who has a precedence under the rule?
But he never be at the vice chairman, my lord.
Oh, all right. Anything else to say?
That's what, my lord, I just want to bring this, whether it is the judgment passed by the common judgment will be
Yes.
binding to this court, since the order has not indicated any reason, my lord.
Okay.
So I'll be citing this judgment of
Yes.
3 judgments from Supreme Court, my lord. In 1991, volume 4, ACC 139, my lord. This is a case of state of UP and others versus synthetic and chemical and others.
Hmm.
I'll be taking to para 39, 40, 41.
Yes, please.
Before 39, I'll read this 39, my lord. But the problem has arisen due to the conclusion in the case of synthetic and chemical. The question was if the state legislature could levy van fee or excise duty on industrial.
You're reading from
Para 39, my lord.
para 39, just hold on. Let's get. Yes.
The bench answered the question in the negative as industrial alcohol being unfit for human consumption. The state legislation was incompetent to levy and duty of excise either under entry 51 or entry 8 of the list 2 of the 7th schedule. While doing so, the bench recorded the conclusion extracted earlier. It was not preceded by any discussion. No reason or rationale could be found in the order. This gives rise to the important question of the conclusion is law declared under Article 141 of the Constitution. It is per inquirium and is liable to be ignored. 40. Inquiria literally means carelessness. In practice, per inquirium appear to mean per ignoratum. English court have developed this principle in relaxation of the rules of the state decision. The quotable in law is avoided and ignored. If it is rendered in ignoratum of a statute or other binding authority, same has been accepted, approved and adopted by this court while interpreting Article 141 of the Constitution, which embodies the doctrine of precedent as a matter of law. In Jaisi South versus Dupe, this court, while pointing out the procedure to be followed when conflicting decisions are placed before a bench, extracting a
Before you delve into this, Mr. Abhilash,
Yes, my lord.
you are asking us to comment on the correctness or otherwise of the single bench judgment.
Yes, my lord.
And supposing we declare it to be absolutely valid in the eyes of law, what happens to your appeal? Have you thought of that?
That's what, my lord, why I am coming here is that I just want to apply. This appeal is coming on 5th.
Maybe,
Yes,
maybe. So you want us to preach us that appeal?
No, because so far as when I entered the appearance, I have already taken that for the final disposal on 5th. My lord.
It's okay that you get it decided.
Yes.
But if you want us to comment on the single bench judgment and you take our opinion, whether your division bench will be able to take a different view.
But in regard to the section 13, I think we can argue the thing, my lord, because. the
13, we have heard your arguments.
Yes, my lord.
We'll consider your arguments, no dispute. But about the validity of the single bench judgment, which is under consideration in another appeal
No,
before the Manipur High Court,
Yes, my lord.
you are asking us to comment.
No,
You
what,
take your comments, then all right.
what my submission is that since all the order has been passed in terms of the common judgment, the learned single judge, my lord.
That judgment says, just hold on. That judgment says the term of ADC will continue till you declare the elections.
Yes, my lord.
Have you complied?
No.
No.
we are
So you have not complied it.
We are not
So
covered.
that
Because-
judgment is no longer in force. As a matter of fact, the issue is now only caretaker arrangement. Caretaker arrangement. Do you have a right of giving preference to an ordinary member or a person who is selected as a vice chairman? That is the only issue before this court. No other issue. Yes.
But the thing is that, my lord, for
Yes.
regarding when the vice chairman or chairman whose term is already expired.
The term of
Nobody is
this,
there, my lord.
term of that respondent number 4 whom we have appointed, it has also expired. You could have appointed any person from the market.
Because when we appointed as an administrator from the official side,
Yes,
in terms of the act and rule, my lord, administrator cannot be appointed.
cannot
from
be
the
appointed.
district, my lord.
So the
Right.
proper way is to do it from the persons who were earlier elected. And from them, if there was an sub-election of a vice chairman, why not give him preference? What is the problem? When more particularly, this we are saying third time, you have not controverted that submission in your affidavit, which you don't deny.
Yes, at the time of filing affidavit, we are not.
Yes.
Right. Subsequently, we came to know that this was the order.
Even if that was an order, it's a subsequent election.
That submission was taken by the learned.
Even if we assume that this was the order whereby earlier there was a vice chairman, he was removed or he resigned, whatever it is, there is a second election. And that election is the domain of the council as per the act and the rules.
Yes, but it has to be notified to the government.
No, there is no requirement. Sorry,
No,
we
it
don't
is
accept
required.
that.
It is
Unless you
required.
show us the provision.
My lord, it can be seen from the order that the resignation order accepted by the authority, my lord.
It
When
may
our-
have been, there's no requirement. Without there being a requirement, if you notify, that's your sweet will. We are not bothered. Now we are examining the fact whether there is a requirement of notification or not. It is not there in the react.
For my knowledge, my lord, I think the government has to issue one order. Alice,
Mr. AAG,
my lord,
you are here in the Guwahati High Court arguing the matter on behalf of state of Manipur, and you are hitting in the dark. That is not acceptable. You could have come out with any rule, any administrative practice that yes, this is the practice that we have to notify.
that is what I am given.
A single instance.
No, by one order has been given, my lord, regarding the vice chairman resignation has been expected by the state government, my lord.
All right. Okay. Very well.
There, my lord,
We'll
that has
check
to be. So
We'll
in
check.
terms of that, by the appointment of the vice chairman has to be notified.
Okay. Very well.
And then what is the use of the issuing this order?
Where is the
that-
gazette notification? Where is the gazette notification of this? Notified means notified in the gazette.
Which one, my lord?
Notification means notification in the official gazette,
Yes.
right? Where is the notification?
Notification for the, this thing, my lord, appointment elected. This is for the resignation accepted by the.
So
committee.
for the appointment, there has to be a gazette notification.
Yes, my lord.
For resignation, even if it is notified, there is no requirement of a gazette notification. What kind of absurd arguments you are making?
At least, my lord, for the elected person.
You
they
be
have to
consistent,
notified.
Mr. AAG, that if there is a notification, notification has to be in the official gazette. There can't be in any other manner, right?
Right.
So where is the official notification of this order which you have placed on record?
That
Is
I-
not there?
No, I'm not. I have.
Has it been sent? Has it been sent? Let us see. We'll find out. Let's see. You take out your copy. Has it been forwarded to the gazette? All right. Take note.
My lord, it has not been forwarded. my
Not been forwarded. So
These are
there is
notification.
no notification in
Yes.
the eyes of law.
That's why I said, my lord, notification has to be issued from the authority also regarding such and such
It is-
person has been.
Mr. AAG, notification means notification in the official gazette. Without that, it is no notification. You have not even sent that copy for publication.
But this one, my lord, at least I have to be examined. Because, but this was we placed before the learned single said at the time of the argument.
We understand that you have said so many times. We'll take note of your submission, okay? Very well. But you tell us now, you really want us to comment on that single bench judgment? Make a statement. Now we are online. We are on live. You make a statement that you want us to make a comment on that set of judgments.
Which one, my lord?
The one which is subject matter of challenge in Manipur.
That
You are inviting us to do that. Are you sure?
Because the matter is coming on fifth,
That's-
for my
It
request.
will
my
not be
lord.
fair for you.
Yes,
That
for-
argument was, as a matter of fact, not
My lord,
required.
what my
We
submission. is
told you
that-
we
Yes, my
are
lord.
limiting the matter simply to the aspect of interpretation of Rule 30 and whether he was a vice chairman or not, simply to that extent, nothing beyond that. And your argument regarding notification, we'll take note of that. Okay?
Yes.
We'll take note.
But the problem is that, my lord, all the judgment passed by the learned.
Problems are all created by your state.
I'm saying coming.
Yes.
All the order passed by the learned single said, by relying the early judgment of the common judgment, which is pending before the division bench, my lord. And the matter is coming on. fifth.
Present judgment is not based on the earlier set of judgments.
No, my lord, it is.
There is no controversy in relation to that. They are not saying that they are not in contempt, that you have not complied with that judgment.
What my submission is that,
Yes.
suppose writ appeal is success, my lord.
Yes.
If writ appeal is success, that
Yes.
nobody should be appointed after the expiry or this till the.
So then even your appointment order
And
goes.
This will be covered by that order or not, my lord.
Let's see whether our order comes first or that order comes first.
This I left it out, God, my lord.
This
But my
unnecessary
submission-
controversy created.
Yes, my lord.
There's a simple way. You should have said that, yes, all right. If you had material on record to say that he was not the vice chairman, he had no case to
I
argue.
am submitting very fairly is that, my lord, since when I take up the appeal, which is endorsed to me, my lord,
Hmm.
I have pressurized the court for taking up this appeal. Because of this appeal, lot of judgment has been come out. Similar matters like the municipality.
That's right.
and,
Things
this
should not be kept pending.
panchayat cases.
These issues
Because
should
all
not.
this has been already expired.
Yes.
And by taking the.
But why
judgment-
are you not calling for the elections then?
No, because we have started a notification. for
Started
municipal-
when?
My
You
lord,
should have done it long back.
No, by municipality, we have started the notification because of the law and order
When the
situation.
Term
We have-
expired in 20 till middle of 21, you were faced with COVID. What thereafter?
Yes, but I want to submit that. There was only 6 ADC in Manipur, my lord.
Subsequently, 4 district has been added, my lord. So before in 2015, we was holding only 6 ADC. Now we have placed before the Hill Area Committee, whether this 4 district also has to be included in the next election. So they say, my lord.
This is a development. This is a development of 2023.
Yes, my lord.
So you are already late by more than 3 years in holding the elections. So this is a mess, plain and simple. We are observing mess created by your government. No one else. No one else is responsible. Yes, you have to say.
I represent the respondent number 4, my lord.
Yes, please. What is your response to their assertion regarding the election as a vice chairman? You are a part of that process. You are a member. What is your reply?
Yes, admittedly, my lord, to be very frank, I would like to submit that in while filing the affidavit of opposition, we do not deny the contention
So
made by the.
then you are not allowed to take a different stand here now.
But my lord,
We'll take note of the fact that you are a member, and being a member, you have not denied this fact.
Yes, I did.
Yes.
Admittedly, my lord. But later on, my lord, after at the time of hearing of the writ petition, it has been brought to our knowledge that there was no any order issued by the competent authority for appointing him as vice chairman. my
Again,
lord.
you are adopting his arguments. Tell us the provision that there has to be an order of the competent authority. Tell us from the rules and provisions. Yes, learned advocate, additional advocate general has tried absolutely to his heart's content.
Yes, man.
And yes,
My lord,
really
that
been
rule-
forceful. We would say we appreciate the way in which he has presented the things.
The rule which has been framed under section 21 of this ADC Act of 1971.
Yes.
At the moment, I'm extremely sorry to submit that we are not with that rule. But
Rules we are having, we'll provide. All right, give him the rules.
that election rule is not there. That is, I think that rule must be 1972, my lord.
Yes. So
Under section 21 of this ADC Act 1971, a rule is to be framed, my lord, for holding the elections and other things, my lord. But at the moment, my lord, I'm extremely sorry to submit that we are not with the rules, my lord. But as rightly pointed out by our learned Edison AG, that my lord, after the my lord resignation of that earlier vice chairman, my lord, a notification should be issued for holding the election.
Mr. Double AG, Mr. Double AG,
But it is not known, my lord, whether it was done or not, my lord.
read rule 21. What is required to be published?
Yes, I was forget to read rule 23 also.
Rule 21.
Rule 20.
What is required to be recorded?
Publication of minutes, my lord.
That's all.
And
No notification.
Yes, my lord. And
And rules for publication are left to the discretion of the council. There is no requirement of an official notification. Okay, that's all. That's only thing we wanted to clarify. So the requirement is only of publication of the minutes as per the rules to be framed by the council. Nothing beyond that.
yes,
No,
I forgot to read this section 23.
23 already.
Yes.
Read.
Chairman and.
Section or rule?
Section, my lord. My lord was wearing, so I forgot this section, my lord. This one,
23.
Section 23.
From which provision?
This Hill Area Act 1971. Manipur Hill Area District Council Act 1971.
Yes.
Chairman and vice chairman, my lord.
Section 23. Just a moment.
My lord, got it.
Yes, just.
The district councils shall as soon as maybe choose 2 members to be respectively chairman and vice chairman thereof. And so often as the office of chairman or vice chairman become vacant, the council says choose another member to be chairman or vice chairman as
Yes.
case may be.
So that is precisely what they are relying upon, that the
Provide-
council has chosen.
Then, my lord, provided that the administrator may nominate the first chairman who shall hold office.
So
for
the
the period
state as an administrator has only the power to appoint the first chairman for a period not exceeding
One
1 year.
year.
That's all.
Yes, my-
State has got no other power under
So when,
state in the capacity of the
yes, my lord, when the state is not having in this act and rule, my lord, then at least for the smooth functioning of the administration, state has to make some policy, my lord.
Please don't repeat the arguments.
Yes,
Those arguments will
Yes,
take
ma'am.
note of.
Yes,
But does the act indicate regarding notification? No. So that's why we showed the rule to you, wherein the publication is only of the minutes of that meeting. That's all, under the rules. Nothing beyond that. And that also, as per the procedure laid down by the council.
Yes. So far as my note, the distinct one, we have one election conduct rule also regarding this meeting.
We are not benefited by the rules. If you are having it online, you can tell us if there is any particular feature.
I left to the court, my lord, for any.
Are you having those rules in the electronic form?
No, my lord, I'm not having in the next time, my lord, my lord is not going to dispose the matter. Then we have this Manipurian area of all this contact with thousand also, my lord. I have to have all these things for them by, because.
We are not leaving anything now.
My lord, we after 2000, my lord.
Mr. Davaleji, don't even entertain a thought in your mind that we are keeping anything pending. That's not in the procedure of this court. Once the arguments have been heard, the matter has to be decided this way or the other. Yes, now you can continue.
But at least my judgment citation might be.
Yes, we'll take note of it.
I have given 3 judgments.
You have given only one. The others you have not referred.
Yes, I.
Because we put a particular query to you. Then you said that no, you don't want our comment on that. That's a risk which if you are prepared to take it. We don't know.
But so far as taking the judgment of the single judge by passing the remaining jurisdictions, my lord. In terms of that, only this order has been come out. What I want to say is that judgment will not be binding for the.
Division bench, all right. Okay, very well. That will.
Yes, my lord. May I continue, my lord?
Yes, please.
My lord, no, just now our learned AG also submitted that, and learned council, Senate Council for Appeal also submitted that the term of this autonomous district councils in Manipur expired for this expired in June 2020, and even after that extension of 1 year, as per section 13, my lord, it lapsed in 2021 June, my lord. Then, my lord, and thereafter, my lord, my humble submission is that there will be not be any post of this vice chairman. And then on, my lord, on 17th of May 2000.
So is there any post of member then? Is the position of member sustaining after that? You have been appointed as in what capacity? As a member?
As a member, my lord.
So is your position continuing as a member?
No, my lord. That is admitted, my lord. And then, my lord, and on 17th of May 2021, my lord, the earlier chairmen were appointed as caretaker chairman, my lord, by the government. And in that order also, this post of vice chairman.
Okay, just an off the cuff query. What about the other councils wherein we presume that in all councils, former chairmen were appointed, right? In other councils, what is the position? The former chairmen are continuing?
But so far as my knowledge, in one Tamelong case, the case is pending before the court. They also challenge the same thing.
The appointment of the chairman as the administrator.
Yes,
No, Lordship.
You are having any idea?
Or in other ADC, Lordship, the caretaker chairman are continuing.
Okay.
And then, my lord, on after dispense of that order 17th of May 2021, page 143, my lord. May I kind enough to see, my lord, page number 143.
143?
143, my lord, 143.
Yes, please.
Of the memo of appeal, my lord. On this order, my lord, that is 17 May 2021, all the existing chairmen, my lord,
were appointed.
My lord.
Not the existing, they are erstwhile. They could not have been existing.
My lord, the order says so, my lord. That's why
the order is flawed, plain and simple. The order is flawed.
With the kind permission,
this presumably because the single judge order was continued.
Yes, ma'am.
Yes.
In supersession of the previous order, government order number so and so,
Yes.
that is 30/11/2020, and in consideration of the recommendation of the State Executive Committee, Relief and Disaster Management Department, the Governor of Manipur is pleased to appoint all the existing chairmen of the Autonomous District Council as caretaker chairman. This is an interim measure till the election of the Autonomous District Councils are held. The caretaker chairman shall not exercise any financial powers and shall look after the normal routine duties of the councils. Further, the deputy commissioner and the chief executive officer concerned of district shall be the joint signatories for all the financial transactions of the councils, my lord.
Yes.
So in this order also, my lord, my humble submission is that only the then chairman, we are given this caretaker status.
Yes,
But vice chairman, it remains silent. It is not there, my lord.
I'm not supposed to appoint two caretakers at a time. Na? There could only have been one caretaker.
Yes, ma'am.
There couldn't have been two caretakers.
Only my humble submission is that only those then the
So
chairman.
in the order of precedence, who comes after the chairman in a council?
That is the vice chairman normally.
So that is a simple question to be answered.
That is naturally vice chairman has to come up, my lord. Then, my lord, on 6th of June 2022, the then chairman, my lord,
Resigned.
tendered his resignation, and that was accepted on 27th of June 2022.
Yes.
At a relevant point of time, also the petitioner, my lord, the present FLN, despite knowing fully well that the then chairman have already tendered his resignation after serving as caretaker chairman, he remained silent, my lord.
Yes.
He did not raise his voice. That I was elected as vice chairman.
He was expecting that the government,
my lord.
he was expecting that the government will act as per law. That was his thought probably.
But my contention is that, my lord, he should have raised his voice at the relevant point of time that as I was elected as a vice chairman, when the office of this chairman becomes vacant, I have a right to be considered, to be appointed as a acting chairman, my lord. But he did not do so. He remained silent.
Yes.
And then, my lord, on 14th of March 2023,
yes,
when this, my lord, caretaker chairman post was extended in page number 157, next 18, my lord. Page 157, annex 18, which was just read out by Olan, Assistant AG. In this case also, my lord, when this order was issued, the para number 3, in view of the above, Honorable Governor Manipur is pleased to allow the last constituted caretaker chairman, Autonomous District Councils, concerned to function as caretaker chairman till issuance of the notification for the election of Autonomous District Councils, Manipur. In this order also, my lord, vice chairman was not included, and he remained silent. He did not challenge it. Only as and when I was given this charge of
So
caretaker.
he has a grievance that the government has broken the protocol and appointed as a simple member, formal simple member as the caretaker chairman, whereas a vice chairman is there. So that is the grievance, and rightly so. What is wrong?
But our humble submission is that he remained silent for many months together.
Yes.
And only as and when I was given this
Under the belief that the elections would be held.
27 of March 2023, he woke up from slumber and questioning the legality of this order, that despite there is a vice chairman, one ordinary member was given.
So if there is a delay in challenging the order or delay in approaching the court, could the court have issued a mandamus? All right, tell us.
No.
That just
I'm not saying that there is delay.
A question now, since you are raising this argument, would the court be in a position to issue a mandamus to the government that you appoint caretaker chairmen?
No.
Is it permissible?
That is not issue.
Then what he would have done by waking up earlier?
Only my humble submission was that when this my lord, this chairman post became vacant on 27th of June 2000.
So he did not take any action. All
He
right.
did not take any action. Only as and when I was appointed on 27 March 2023.
Okay.
He raised so many grounds that because of such and such rule and others, I should be given appointment as caretaker chairman. And without doing that, the present respondent number 4 was given appointment to the post of this caretaker chairman.
All right. All right.
And that is why, my lord, we have submitted that he doesn't have any right to challenge this order of 27 March 2023, as he remained silent when that post was became vacant.
Very well.
And then, my lord, our learned legislature has also, my lord, pointed out that, and it may not be, my lord, fear on my part, my lord, to raise certain, my lord, grounds and issues in respect of the validity and legality of that, my lord, judgment passed by learned single judge. That regarding that, my lord.
You are not a party to those writ petitions.
Yes, I was a party.
So
but
you are not supposed to make.
But if your lordship kindly permits me regarding a law point, my lord.
Yes, of course.
That judgment of the 2nd March 2021, my lord, as I was a stranger to the proceedings, it may not be fair on my part, but but legally, my lord, this judgment
legality of that judgment is already under challenge. How many times we have to express that fact? We are not called upon to exercise the great appellate jurisdiction to
This,
examine the validity
Yes, my lord.
or legality of that judgment.
But with due respect, my lord, to this judgment, my humble submission is that in fact, this judgment should have been confined only to that, my lord, extended period. That because of that section 13(1), only 1 year period can be extended at the most, my lord.
That's right.
And this para number 17 of the, my lord, of this operative portion of this judgment, it says that, my lord, unless the election process is, my lord, finalized, then, my lord, the interim order granted on 27/11/2020, passed by the honorable court in the WPC number 612/2020 shall continue, my lord. So in my humble opinion, I would like to submit that this judgment, my lord, runs contrary and or overrides the statutory provision of this Act of 1971.
Yes.
So it will not have any binding effect, my lord. And today, the effect, my lord, if it also kindly permits me, I would like to cite only one judgment of the Honorable Supreme Court, my lord. Regarding that, my lord, the conflict between the equity and the law, my lord. My lord, this is 2007, volume 2 SCC, page 230, my lord.
Yes.
In that case also, my lord,
Have you given the list?
Yes, 2007, 2 SCC, 230, my lord. In that case also, my lord, the Honorable Punjab and Haryana High Court, by exercising its power under Article 226, my lord, passed certain, my lord, order by transferring one petition before the company law court tribunal that was SL before the Honorable Supreme Court, my lord. Let me straightway come to, my lord, page number 241, para number 29, my lord. Para 29, my lord.
Yes, please.
Lordship got it, page 241.
Yes, yes.
With the kind permission, I read out para 29, my lord. Learned counsel for the respondent bank submitted that it will be very unfair if the FLN, who is the guarantor of the loan and the director of the company which took the loan, avoids paying the debt. While we fully agree with the learned counsel that equity is wholly in favor of the respondent bank, since obviously a bank should be allowed to recover its debts, we must, however, state that it is well settled that when there is a conflict between the law and the equity, it is the law which has to prevail in accordance with the Latin maxim, dura lex sed lex, which means the law is hard, but it is the law. Equity can only supplement the law, but it cannot supplant or override it. Para 30, my lord. Thus, in the Madamansi Ramappa versus Muthala Rubra Bojappa, here such and such, what is administered in courts is justice according to law, and the considerations of fair play and equity, however important they may be, must yield to clear and express provisions of the law. Para 31, my lord. In Council of Indian School of Certificate Examination versus Issa Mittal, my lord, reported in, my lord, 2003 SCC 541. My lord, this court observed considerations of equity cannot prevail and do not permit the High Court to pass an order contrary to the law, my lord. Then, my lord, para 32. Similarly, in PM Lata versus State of Kerala, this court observed equity and the law are twin brothers and the law should be applied and interpreted equitably, but equity cannot override written or settled law, my lord. Then, para 33, my lord. In Lakshmi Narayan R. Bhatta versus State of Maharashtra, this court observed it is now well settled that when there is a conflict between law and equity, the former shall prevail. Para 34 also, my lord. Similarly, in Nasiruddin versus Sitaram Agarwal, this court observed in a case where the statutory provision is plain and unambiguous, the court shall not interpret the same in a different manner only because of harsh consequences arising therefrom. Para 35 also, my lord. Similarly, in P. Palaniswamy versus Palaniswamy, this court observed equitable considerations have no place where the statute contain express provisions, my lord. Then, my lord, let me come to, my lord, last para, my lord, para 40, my lord. Page number 243, my lord. It may be mentioned in this connection that the first and the foremost principle of interpretation of a statute in every system of interpretation is the literal rule of interpretation. The other rules of interpretation, example, the missive rule, purposive interpretation, etc., can only be resorted to when the plain words of a statute are ambiguous or lead to no intelligible results, or if read literally would nullify the very object of the statute. Where the words of a statute are absolutely clear and unambiguous, recourse cannot be had to the principles of interpretation other than the literal rule. The language, next page, my lord. The language employed as held in Prakashnath
Khana versus CIT, the language employed in a statute is a determinative factor of the legislative intent, my lord. Next sentence, I give my emphasis, my lord. The legislature is presumed to have made no mistake. The presumption is that it intended to say what it has said, assuming there is a defect or an omission in the other.
Okay, we understood this principle. Now we put your question.
My lord,
Where there is a gap
my lord.
in the law. Just
The,
hold on.
my
Hold on,
lord,
please.
the relevancy is that, my lord, the
Please,
judgment
please.
and order dated, my lord.
Mr. Counsel,
Yes,
will you please respond to our query? We understand your
yes,
submission. That equity cannot override law, right? But where there is a gap, a latent wedge in the law, which by no stretch of imagination can be filled,
yes, ma'am.
are the courts supposed to act as mute spectators? Tell us what happens after that period of 1 year extension. How long can the state government sit tight and not let the democratic institutions function? Tell us, what is the extent of that period? 1 year, 2 year, 10 years? The courts would act as mute spectators. What the courts will do?
My humble, my lord, reply is that, my lord, when that batch of liquidation were disposed of, my lord, and a single just, my lord, the government of my lord could have been directed to finalize all those matters within that extended period of 1 year, my lord. But the Lana single just would you
That
respect, my
period
lord?
expired in 21.
But
the
this judgment
courts
was, but this
just-
judgment was passed before expiry of the period.
Yes. So what has the government done till now? Tell us. We are asking you. We are asking the double AG. Even as on date, do you make a statement that the elections have been notified? We are in 23, nearing end.
Yes, ma'am.
Is there a notification?
No, ma'am.
Then what are we discussing here? So there is a clear gap, a gray area in the act. What is the consequence of non-declaration of an election after expiry of 1 year? So where the act is silent, the learned single judge has made an interpretation. Simple as that.
But my lord, this act, my lord, section 13(1)
Yes.
clearly says that, my lord, at the most, my lord, the government can extend its term for a period of another 1 year, my lord.
Yes. So that is upon the government.
So
And if the government, after extending the period or not extending the period, keeps on sitting tight over the matter, not declaring the elections, what are the democratic institutions supposed to do? How they are supposed to act? And what are the courts, constitutional courts in this country meant for? Okay, thank you. Anything else to say?
That's all, ma'am.
Okay. You have to say anything in rejoinder, please?
Lordship, many things have been pleaded outside the pleading. But Lordship, only I will clarify one thing. My learned additional advocate general made a submission that there is a policy. Cabinet decisions have taken a decision, but it only remains in the file, not notified, Lordship.
Not notified.
Procedural Singh case, Lordship, versus State of Punjab, 1962, is very clear, my lord. That is 7 judges bench, Lordship. That is follow as on today. I'll give the citation, Lordship, 1960, 1962, 1963, AIR 395. It is a 7 judges bench, my lord.
Page 953.
Yes, 395.
395.
Yes. What would be the essential order, which can be considered as an effective order? That is given judgment, unless it is communicated to the party affected.
No, what policy they have placed on record.
Yes.
That is not even a policy decision. as a
Right.
matter of fact.
It is not.
They
even a
only say
policy
that
decision.
it is
only remains
in the
the
stage
file.
of contemplation.
Yes, it only remains in the file.
Yes. Agenda 4, ADC election schedule. Approved to schedule the ADC elections in the month of October 22. What thereafter? So policy has never been executed, never been published as a matter of fact, as you
Also,
say.
during the COVID in 2020, by-election assembly was held.
Assuming we leave that period, but thereafter even period of 2 years has gone.
Yes, ma'am.
Approved for introduction of so and so bill 22, whether it has been introduced, silent. All right. Still the views are sought for. approved for placing the cabinet memorandum for its decision. Thereafter, what is it? Okay. Arguments or judgment reserved.
Thanks for my.
We appreciate your arguments. What's your good name, please? What's your good name?
My name is Devananda Singh.
Mr. Devanand. Okay. You appeared in the single bench also.
Yes, fine.
Okay. But why your VC connections are so bad? The facility is not functional properly or what?
Yes, because of the internet ban only.
That time there was a
yes,
ban,
Recently it was open.
Even the broadband is not functioning.
Probably only some areas, my lord. We are not giving all the people's, my lord.
Okay.
We are scrutinizing the thing.
We understand. That's right now the situation is that way, right?
Yeah, because it's.
But things have improved now.
Yeah, 2 days back, it was started again because of the 2 students has been killed by the.
It's really.
Okay.
People must be facing really difficulty. Yes. Okay.
Passed over matter, item 21.
The applicant before Lordship, my lord, a retired employee, my lord, claiming for outstanding dues and my lord current can say benefit. Lordship, can you see order it is 16.8, my lord?
Yes. What do you have to say?
Your lordship, as per the instructions from the board, they are looking at some other possibilities to disburse the pension, your lordship. Currently.
What about the current benefits?
Yes, your lordship, I understand. However, there are other similarly situated persons. So they are exploring some other alternate possibilities because the current source of income, the current income that they earn from different sources, it's not enough. Kindly grant us 3 more weeks time, your lordship, so that we can come up with a concrete mechanism. with regard to-
Lordship, until unless Lordship little bit.
We'll put a stay on the salary of all government employees then. Right, current salary will stay. What do you say? You pay out of the salary head.
Then I think something.
Keep your CEO present in the court. Despite pertinent direction given by this court regarding, despite the order dated 16/8/23, Mr. Chamadia states that the current pension is also not being paid to the petitioner. In view of the facts noted above, we hereby direct the Chairman Golpada Municipal Board to remain present in the court.
Along with CEO, my lord.
And the CEO to remain present in the court on the next date list on 17th October.
17.
Passed over matter 22.
Yes, my lord.
This was, I don't know. Yes.
I appear for the respondent number 1 and 3, the Council of Architecture, my lord. My lord peruses the last order. The appellants were supposed to file an affidavit. And we were also given an opportunity to reply to that affidavit, my lord. That affidavit has been filed today. And moreover, my lords are sitting on appeal against the judgment and order passed by the learned single judge. Now, my learned friend has raised that argument that the order by which we have levied some charges for establishment of new colleges, it's not valid and it's not legal. However, my lords, the honorable single judge had dismissed the writ petition on the ground that the order itself was never challenged in the writ petition. So my lord is aware, my lord, is the basic order is not challenged.
You are arguing the matter today.
No, my lord, no, my lord. No, that is one point on maintainability. My lord, he has not challenged the order at all. Till date, it has not been challenged. He has challenged the letter which has been issued to him, my lords. But the main policy decision is not under challenge. So my lord will not take up an exercise of adjudicating.
We're raising the question, lordship, prior to lordship, with all respect.
That's the preliminary objection sort of thing. So he is right in raising it. Yes.
only legal point is that lordship, whether they can.
Power to raise.
Only that, and my learned friend lordship, the Union of India lordship is there in the morning, he has. They have.
The occasion did not arise
No,
before
no,
the learned
Lordship.
single judge. We can adjudicate that point because that order itself was not under challenge.
Lordship,
Whether you have a power under the eyes of law to impose that kind of cost. That is what is under challenge.
That
The levy itself may not be, but the very power to do it. So the foundation is challenged.
the foundation, my lords, they have not challenged the policy decision.
Let's see, read the
My lords,
pleadings then.
my lords,
So you want to first to
read-
decide the matter on this?
my lords,
You want us to decide the matter on this?
Our lordship would give me an opportunity. I'll reply to that letter, but my issue, my maintainability may be open, kept open.
Of course, we are not deciding it right now then.
My lords,
If you are raising it, we'll decide it right
my
now.
lords, my lords.
If you are raising that issue, then we'll decide it right.
I'll file it on affidavit, my lords, again.
And council appearing for Mr.
1 and 3, my lords,
1 and 3.
Council of Architecture.
COA raised for and is granted further opportunity of 3 weeks to file affidavit on behalf of such respondents.
Deeply obliged, my lord.
lordship, with all respect, lordship, my learned. Lordship, learned friend, lordship already filed his affidavit there, lordship, on that point, lordship.
My lords,
With all respect, just it is delaying, lordship. Only that
You
point.
file your affidavit in the rate petition, we presume.
In the writ
Then why do you
petition,
need a fresh
my
affidavit?
lords,
What is
kindly
the-
page the last order, my
Yes.
lords, last order.
If the pleadings are already complete,
Last
this
order,
is
my
a
lords,
writ appeal. Why do we
last
need?
order, my lords, kindly, my lords.
Yes.
Kindly page the last order.
Sought approval, not approved. So you are supposed to place on record those minors.
Yes, by
Lordship,
way
I
of an
already-
affidavit.
You already done it.
Lordship,
my lords,
I
today.
already filed it, no. I filed it by learned friend. Actually, I served the copy to the Union of India already. No, you see, let me submit.
All-
I have a.
You, Mr. Mazumdar,
Lordship.
you have filed the minutes today.
No.
Then
It was filed on 9, lordship, 12/9, lordship.
12/9.
12/9 before this honorable court, lordship. By serving a copy to the Union of India, my learned friend was not in the morning.
All right,
lordship,
you have given him a copy today.
Lordship,
Let him
actually,
respond.
that part,
He's
lordship,
submitting
I tried my lordship with all fairness, lordship, submitting lordship, maybe on the mistake on.
Copy of the affidavit dated 12/9/2023 filed by the appellant has been supplied to the council representing the responsibles 1 and 3. He prays for short opportunity to respond to the amendments made in this affidavit.
Deeply obliged.
List on 16th November.
Deeply obliged.
Item number 29 for final disposal.
Lordship, this is the case of settlement of a fishery lordship.
Yes.
Before the single bench, we have taken a ground that the private respondent herein is a defaulter.
Is a defaulter.
Yes,
Okay.
lordship. And if I may take your lordships to page number 55, lordship.
Page 55.
Page 55, paragraph 8, lordship.
What is the stand of the corporation? Is it the corporation or who?
Government.
State?
State.
Fisheries Department. What is the stand of the Fisheries Department? There's a default, so he can't continue with the settlement. That's the consequence. Yes,
My lord, so far the issue of defaulter is concerned, my lord. That was, my lord, decided in single judge in paragraph 14, my lord.
yes.
Paragraph
Let's see.
14 of the judgment, my lord, page.
So specifically denied liability against the government revenue, and the assertion has not been denied by respondent but so and so. Non-traverse. Now it's a stand of the department that you are a defaulter.
No, my lord, at the time of my lord, making settlement, we are not the defaulter, my lord.
Subsequently, if you become a defaulter, then what
Well,
happens?
that was not known, my lord. But
Not
settlement was made on the basis of the NID, my lord.
Let us see.
Well, it's the NID, my lord, page 33, my lord.
Previous default for the tenure 2005 to 16 and default is of 25 lakhs. The inquiry has been done. Have you got a copy of this letter dated 2nd August?
Malad, it was subsequent making the settlement, Malad. It was in
No,
2022.
no. This is a due of rupees 21 lakhs 71,500 tenure from 2006 to 17.
No, Malad, that was not, according to me, no, Baki Jai, Malad.
Read this. That you have filed it on record. Provide a copy to him. You have not got a copy of this
No,
letter?
Malad, nothing.
Have a look at it. Copy of the letter dated 2nd August 23 has been provided to learned counsel. Your good name, please? DK Das, representing the respondent number
1.
A perusal of this letter would establish that the DC Nagaon, after making thorough inquiry, has reported that outstanding of rupees 21 lakhs 71,500 was due against such respondent from the tenure of fishing settlement between the years 2006 to 2017, and that the defaulter deposited a sum of rupees 4 lakhs against the said outstanding. Further notice has been issued to the defaulter on 15/7/23. Learned counsel Ms. Das praised for his granted short opportunity to respond to this letter / communication list on 11th October.
Malad, can be after vacation, Malad?
No.
Malad, the respondent one is undergoing, Malad, operation, Malad.
Absolutely no.
He was, Malad, renal.
The fact that you have deposited the money 4 lakhs, that establishes your default is writ large on the fact. There is nothing to dispute.
No, Malad, we run the fishery prior to this, and we have paid all this money. But how it was pending?
How it was pending, we don't know. That's an inquiry report. Get an answer. You can't be allowed to continue the fishery. Absolutely no.
No,
11th
Malad,
October.
according to me, no letter, nothing of the sort.
You
was
have
given to
deposited
the
4 lakhs, gentlemen. That's what the communication says. What more is required?
That communication was not to me, Malad. That was not sent to me, Malad, till date.
Your client has deposited 4 lakhs, so he has rather misled the court in the process.
4 lakhs, Malad, this present settlement.
No outstanding of 2006 to 17.
Malad, we'll file
Yes,
reply, Malad.
11th October.
Item number 1 and 2, top of the list matter.
Some revenue records were to be produced.
My lord, I have a small prayer, Lordship. Lordship, allow me some more time because this is the old.
You were supposed to file something, Mr.
He
Kapote.
was supposed to file.
You were supposed to file something on record. Last date, you had made a submission.
Lordship, we have received records up to 1975, Lordship. Earlier reports we have applied for,
Okay.
but not yet, they have not been able to supply it. We might
What is the
take some
position
time.
in the records up to 75? Was it the
75 says
reflection?
this is land reserved for both the ducks, reserved for fish and cemeteries. Lordship.
Okay.
That is why we want to see the earlier record also. The record is searching.
See the
Lordship.
record, see the record.
Yes.
If it is since times immemorial,
Yes.
it is reserved for cemetery, you can't interfere.
Yes, yes.
Plain and simple.
Yes.
And 75 is sufficiently old.
Yes, so we'll.
It's
let
almost
me-
50
yes.
years now.
He wants more, my lord. That's why my learned senior friend wants more. My
All
lord.
right.
Yes, yes.
Mr. Kakoti submits that he has received the original revenue records for the years 1975.
75.
But the earlier record is still being sought. And Council Mr. Bora, appearing additional senior government advocate, also praised for time to keep the relevant revenue records available.
Yes.
Re-notify for hearing on in the second week of December.
I'm deeply on that.
Before, sir, before. Sir, December, even sir, make it October or something. It is very late, or sir, on November probably.
It can be last week of November, Lordship.
We have got, there's no urgency, you got to stay.
Lordship, so to speak. Yes.
Item number 3,
Oblige.
Yes, Mr. Dey. Now We run out of time so far as the first session is concerned.
Yes.
So come back at 2.
Yes, my lord.
Yes.
Yes. May it please your lordships.
Yes.
My lord, this is an appeal by the respondents in respect of a judgment in order which starts at page 44 of, my lord, is volume A is the re-appeal memo in toto. And that volume will, my lord, at least for the purpose of my submission, contain everything. The re-appeal memo will contain everything, my lord. For me. My lord, I will go a little slow, my lord, because
You take
the
your
volume is such, there's every chance for me to get lost in the woods.
hope that we don't get lost.
No, my lord, never. My lord, page 44, the judgment starts.
Yes, please. And precisely why were you relegated to Guwahati High Court in
My
this
lord,
matter?
there was no division bench available.
At
Because
that point of time, or
my-
even now the same
even
situation?
now, my lord, the honorable, the division bench, the two other honorable judges, my lord, Chief Justice and the other honorable judge, the honorable judge, he recused himself, my lord. He went to Supreme Court and then, my lord,
The other judge recused. All right.
my lord, page 44. The petition number 1 to 15 are the grandchildren of government servants to the government of Sikkim prior to 13/12/1969. My lord, your lordship will kindly see grandchildren, because these are these subtle words will make the difference. Grandchildren of government servants of the government of Sikkim prior to 31/12/1969. Petitioners 16 to 21 are the children of government servants to the government of Sikkim on or before 31/12/69. The petitioners are agreed by the state action by an insertion, my lord will kindly see, insertion was made in the notification dated 22/11/1995 for brevity notification in item 5 therein, qualifying the issuance of certificate of origin, in short COI, to persons whose father husband has or had been in Sikkim government in service on or before 31/12/1969 for the purpose of employment only. My lord, this document is at page 195. I'll take your lordship slowly. My lord, by superseding the other memorandums of 1981, they also assail item number 5 appearing in the notification number.
Just a moment.
I'm sorry.
Yes.
My
Yes,
lord.
please carry on.
My lord. My lord, so in short, they assailed two notifications, my lord. 1996 notification, and then the grievance further extends to the letter bearing number so-and-so dated 2/6/2006. Two notifications are in challenge, my lord. My lord, it's a very well-written, long judgment. I will cut the facts short, my lord. My lord, two notifications are in challenge in 1996 and 2006, whereby they say something was inserted. What was inserted?
Yes, please.
That sons and daughters and wife of government servant was inserted. Number 2 insertion is this COI, certificate of origin, is meant for employment purpose only. These are the two insertions which irked them.
So the exclusion is of the grandchildren and the right to purchase property and other associated rights.
My lord, here they don't say so, but it's apparently for
In
the
the
purpose of
apparently for that
employment.
purpose. Yes, employment.
Employment. Lordship knows the peculiar history of Sikkim. Before merger, some laws created were saved by
We
merger.
don't profess or claim to have any particular knowledge about that.
My
You
lord,
can enrich our knowledge.
my lord, we
Yes.
will refresh our memories, my lord.
Yes.
My lord,
1996 notification, 2006 notification, I repeat, were challenged on the ground that there were some insertions by which grandchildren were left out. And it was limited, the COI issuance was limited only to
Sons and daughters.
son, daughters, and also wife, will stop. Sons and daughters and wives of government servants who served the state of Sikkim prior to 31/12.
So what was the earlier position prior to the insertion?
I am so obliged. There was no insertion.
So
Right from day one,
there was
1976.
only the last cutoff point was the government servant. Thereafter, no inheritance rights, nothing. So you provided sort of entry to the children and the wife.
My lord, children and wife were the benchmark.
Yes.
Grandchildren were not there. They read more into it. My lord, can I for a moment take your, and this was quashed. This was
As
quashed.
per your convenience, Mr. De.
My lord,
Yes. Carry on as per your convenience.
my lord.
Yes.
My lord. My lord, I seek to take your lordship first to satisfy this point, the insertion part. My lord, these two notifications were quashed, holding that they were insertions, they are violative of Article 1416. My lord, kindly come to page 185A of this. (185A). 185A. My lord, it's a typed copy of 185. My lord, kindly see the notification date, 25th of September 1976.
Yes.
My lord, it's just 1 hour after the merger, or 1 year after the merger. Merger took place in April 75, 9th April. Anyway, April 75. This is after 1 year of merger. In order to ascertain the residential qualification of candidates who claim themselves to be locals at the time of seeking employment, it has been decided that candidates should be asked to mention whether their parents' name have been recorded before 15/5/1975 in the relevant government register. My lord, that it is for the purpose of employment, it is clear here. My lord, kindly come next to page 186. This is not very relevant, but still. 186 middle on the first hand column. 28th January 1980 notification, my lord. Just in the middle, 186. Well, it is hereby notified that information of all the heads of department that domicile residential certificate issued by sources other than district collector shall not be accepted as valid. This is in continuation of the memorandum dated 25/9/76. We have just read it, my lord. My lord, next is page 187. Next page.
187.
My lord, yes, 187.
Yes.
My lord, this is dated 9th of April 1981. Memorandum. In modification of this memorandum dated 25/9/76, we just read it, my lord, 185A, and the notification dated 28/1/1980, 186, we have read. The governor is pleased to authorize the district collectors within their respective districts to issue certificates to persons, identifying them in the following groups to enable them to forward, apply for employment in the state. A, person whose name is found in the old Sikkim subject register prior to 75. My lord, we'll go to that later on. A person whose name is not found in the register of old Sikkim subject register, but she has established beyond doubt that the name of his, her father, husband, paternal grandfather, brother, doesn't speak of grandchildren.
So this implies grandchildren, Mr. De.
My lord,
This implies grandchildren. His paternal grandfather.
his
So that
paternal
means the
grandfather.
grandchild is applying.
My lord. From the same further has been recorded in
This would imply that the grandchild is being taken into account.
My lord, this is for the purpose of people whose names are not there in the old Sikkim register, but who say that for bona fide mistake,
they could not apply for their inclusion in the old Sikkim
Their
register.
grandfather could not apply.
My lord,
Yes.
right.
So this takes into account the fact the right or recognizes the right of the grandchildren.
For the purpose of inclusion in old
For
Sikkim
whatever
register.
limited purpose, whatever limited. Yes.
My lord, a person whose name is not found in the register of the old Sikkim subject register.
Okay. Yes.
I'm sorry. My lord, I'm again reading it for my understanding. A person, clause 2, my lord. A person whose, my lord.
Yes, please.
My lord. My lord, 1 and 2 are meant for people. 1 is for persons whose names are already there in the old Sikkim subject register.
Yes.
My lord, may I coin the term original Sikkimis, because this is what is used by legal parlance also. 1 is whose names are already there in the old Sikkim register. Number 2 is persons whose names are not there in the old Sikkim register, but she has established beyond doubt that the name of his, her father, husband, parental grandfather, brother from the same father has been recorded in the old Sikkim register. Third, person who has agricultural land in rural areas and has been ordinarily residing in the state of Sikkim. My lord, only a person who is in Sikkimis with Chogyar's time can hold land. Then fourth, we are concerned with this. A person whose father, husband has been in service of the state government on or before 31st December 1969. Now, my lord, 2 things I seek to call out for your lordship's pointed reference, my lord. This is for the purpose of employment purpose only.
Yes.
And then the person whose names are not there in the Sikkim register, or they don't, those persons are dealt with in clause 4. They are the persons whose father or husband, not grandfather or anyone, father or husband has been in service of the government.
So there is an apparent gender bias, Mr. Dev, in this. Supposing the wife had been in service. Supposing the wife had been in service, what about the husband?
In fact, marriage is taken. Wife is also taken. The clause here is whether children will include grandchildren, great-grandchildren.
We understand, yes.
Because the petitioners are admittedly grandchildren.
Grandchildren, yes.
A person whose father, husband has been in the service of the state government or not, or on or before 31st of December 1969.
So
now, my lord, kindly come to the
this was the original notification.
Original notification.
Okay.
My
Now
lord,
what is the change?
now kindly come to 195, the impugned one. 195.
Yes.
This is the notification where they say, my lord, there has been insertion.
Yes.
In supersession of the memorandum number so and so dated 25th of September 1976, my lord, page 185A, we have already read. Notification dated 20th of January 1980, my lord, page 186. And memorandum number so and so of 9th April 1981, page 187. And circular number so and so dated 17 March 1987 is not there. The state government is hereby pleased to authorize the district collectors, subdivisional officers, and revenue officers within their respective jurisdiction to issue certificate of identification to the persons falling in the different categories as indicated below on the recommendation of the Gram Panchayat and being duly satisfied with such recommendation. A person whose name is recorded in the Om Sikkim register, repetition, a person whose name is not found in the register of Old Sikkim subject, but she has established beyond doubt that the name of her father, husband, paternal, grandfather, brother from the same father has been recorded in the Old Sikkim subject register, or person who has or had agricultural land in rural areas and has been ordinarily residing in the state of Sikkim, or person who is holder of Indian citizenship issued by the district collector, government of Sikkim, my lord, under Sikkim citizenship order 1975 as amended by so and so, or 1989. Then, my lord, this is what they say is insertion. Or a person whose father, husband, had been Sikkim government service on or before 31/12/1969. Certificate of identification obtained by such person shall be for the purpose of employment only. My lord, in my humble submission, the supersession part, which is the beginning word, is in respect of the power granted to the authorities. The lordship is saying district collector, then say others without authority of district collector void, then again say district collector. Now it says, my lord, it specified district collectors, subdivisional officers, revenue officers with permission of panchayat and blah blah. Supersession is only to that effect. My lord, 1, 2, 3, 4, 5. Insertion, if any, is only in respect of 4. They are not 4. 4. Okay. Why, my lord? By that time, the evolution, my lord, our Citizenship Act came into force. There was Sikkim Citizenship Order. I will show, my lord. There were 2 sittings of the Indian government appointed committees who, my lord, recorded, apart from the Sikkim old subject register, about 80,000 and odd persons as part of the Sikkim register. Thereby, old Sikkim is, my lord, rest were all Indian citizens. By virtue of law, after accession, my lord, they are all Indian citizens. Question is whether they are old Sikkim subject or not. That is the only, and why it is a contentious issue, that also I'll bring to your lordship. Yes. So, my lord, my first contention before your lordship is there is no insertion. Insertion, if any, happened in 1976. My lord, kindly come to page 199A. Because this is under challenge. 199A. This is by way of clarification. My lord, 26/2006. Yes. Sir, kindly refer to your office letter so and so, seeking clarification as to whether certificate of identification can be issued to the grandchildren of the persons who were issued with the certificate of identification being regular government service prior to so and so. I am directed to convey that the third generation not covered for issue of COI under notification dated 1995 and number so and so of 1996. Therefore, the present practice may continue. My lord, the first question that will arc probably each one of our consideration is something which happened in 76 and did not undergo any material change whatsoever. What occurred to them that come in 2016? My lord, after a long 40 years, my lord, 40 years, 70s, I think 40 years. A 76 cause of action is brought to your lawsuit notice in 2016 by action.
On the contrary, the contrary question may be asked. If the provision is unconstitutional at the time of its inception, where's the question of limitation coming into?
They never say so. They say, that's why I'm telling, my lord, because then the burden will be different on them. They start with the connotation that is an insertion. The word is specific. Insertion that, my lord, the grandchildren, I'm sorry.
This is not. Okay. We'll talk, right? Yes.
They come up with the contention, my lord, that this is an insertion. My lord, the honorable single judge also takes it to be an insertion, as if it never existed before. It's an insertion for the first time in 1995. We reiterate in 2006 that grandchildren are barred, number one, and two, this COI, certificate of origin, is being used only for the purpose of employment and nothing else. These two, according to them, are insertions, were never there. And the term is very specific, insertion.
Okay.
Now, my lord, this is one part of the story. The other part is how it is relevant, my lord. Why they are so arced about, my lord, this for the purpose of employment only, and my lord, exclusion of grandchildren. My lord, we go back a little back in history, in 1974, just before accession treaty was signed, in 1975, Sikkim became a part of India. My lord, kindly come to page 136 of the same volume. 136.
Yes.
This is a statute of Chogyal time, my lord, Sikkim, original Sikkim time. My lord, Sikkim government establishment rules 1974. Application is, Lordship, what is, my lord?
Yes.
Yes, these rules may be called the Sikkim government establishment rules of 74. They shall come into force with effect from 1/4/74. Application. These rules shall apply to all government servants to the same extent to the government of Sikkim government service rules. My lord, may skip these pages and come straightway to clause 4.4 at page 141. The virus of this rule was challenged before the Honorable Apex Court. Rule 4, my lord. This is actually rule 4.4. 4.1 starts in pre-page 140. This is a continuation, it is 4.4. Appointment. Yes, gets it, madam. Appointment. Appointment to service under the government shall be by one of the two methods indicated below: direct recruitment, promotion from one grade to the other. Direct recruitment shall include appointment on contract or appointment on donation. Now, my lord, proviso. Provided these two types of appointment shall be made, having due regard to the exact nature of specific duties and responsibilities and the qualification required for the post, and further provided that, number one, non-Sikkimese nationals may be appointed only when suitably. Non-Sikkimese nationals may be appointed only when.
There's something objectionable about this. Of course, we are not examining. Once there was an accession, where's the question of anyone being a Sikkimese national?
This was caused to question, and the Supreme Court upholds it. This under 371, the special proviso. This is a safe statute. Don't question.
Okay.
My lord, reading of Article 14 or applying the touchstone of Article 14 will be on the basis of this. Supreme Court says so. My lord, I'll bring to your notice. This first struck me. I asked him, my lord, until he showed me Surendra Prasad's case. Kandi Kaji Lendovdorji's another landmark judgment. 371F was upheld. Other things.
We'll read those.
Interesting thing so far as history is concerned, my lord. I got to learn many things from this.
Yes.
Non-Sikkimese nationals may be appointed only when suitably qualified and experienced Sikkimese national not available. And number two, replacement of such appointees by suitable Sikkimese nationals may be made as and when available. Mutually agreed terms, so and so, so and so. Well, in the editor's note itself,
the judgment is there.
Yes, I think it is Swami. 1994, Surendra Prasad is. My lord, I'll cite that. But big judgment, but I'll show only a small part of it. No, my lord. These exclusively reserves, subject to the proviso, the primacy of appointment in government sector to Sikkimese, meaning thereby old Sikkimese.
Yes.
Now, my lord, what we mean by Sikkimese, we'll try to understand it now. My lord. Yes. My lord, this is the third chapter. Third chapter is domicile, not citizenship, Sikkimese-ness. Page 94, my lord.
Third chapter of what?
My lord.
Third chapter of what?
My lord, this is a third chapter of my understanding. The first chapter was that whether there is any insertion at all. Number two, why they are aggrieved. Is aggrieved because of this. I will try to assist your lordship in the line, my lord, that what has been set at naught in Surendra Prasad by Apex Code, they want to, my lord, do it indirectly, what is not, what is prohibited for them to do it directly. My lord, page 94. Lordship got it. Sikkim Subjects Regulation 1961. Chogyal time, my lord.
Yes.
This is of Home Department, Gangtok, dated 3rd of July 1961. My lord, regulation may be called Sikkim Subject Regulation. It shall extend throughout the territory of Sikkim. Commencement, the regulations will come into force on the date appointed for the purpose by the Chogyal of Sikkim. My lord, I can tell your lordships, it came to effect on 3/7/1961. Page 98 is the notification. My lord, certain persons domicile in Sikkim territory at the commencement of the regulation to be Sikkim subject. Every person who has his domicile in the territory of Sikkim immediately before the commencement of this regulation shall be a Sikkim subject if he was born in the territory of Sikkim and is resident therein, or has been ordinarily resident in the territory of Sikkim for a period of not less than 15 years immediately preceding to the such commitment, provided that in counting of the said period of 15 years, any absence from the said territory on the account of service under the government of India shall be disregarded. Or in the wife or minor child of a person mentioned in clause A or B. Let kindly see. Provided that a person shall not be a Sikkim subject under this section unless he makes a declaration to the effect that he is not a citizen of any other country. He is not a citizen of any other country at the time of inclusion of his name in the register of Sikkim subject to be maintained under this regulation. My lord, shortly speaking, this is the citizenship charter of Sikkim Kingdom, the then. Provided further that in the case of minor or a person unsound mind, such declaration may be made by the guardian. Now, explanation. No person shall be deemed to have his domicile in the territory of Sikkim unless, my lord, domicile is mentioned in the first column also, unless the person who has made Sikkim his permanent home and as, my lord, it is not served, it is severed. His connection with the country of his origin, such as by parting with his property in that country or acquiring immovable property in Sikkim, provided that this person shall not be deemed to have a permanent home in Sikkim if he indicates an intention of returning to his country of origin by keeping a live interest therein, even though he might have parted with the property of so-and-so, and more property, the property shall not be regarded as a proof of person having acquired a permanent home in Sikkim. The wife and minor children, again, my lord, of a person having his domicile in Sikkim shall be deemed to have domicile in Sikkim for the purpose of this section. In any case of doubt as to whether a person has domicile within the territory of Sikkim under the section, the matter shall be decided by Chogyal with the assistance. Certain persons, though not domicile in Sikkim, to be Sikkim subject, any person who has not voluntarily acquired the citizenship of any other country, though not domicile in Sikkim, may on application make the authority to observe the rules under this regulation may be registered as Sikkim subject also. My lord, Sikkim subject by decision, every person born after the regulation shall be a Sikkim subject. If at the time of his birth, the father is a Sikkim subject, my lord, women's status and other things My lord, next page. Naturalized subjects. My lord, my purpose of showing this entire page to your lordship, I'll cut it short, is that it speaks of a register to be maintained under the rules. In this register, the names of persons who are otherwise authorized or, my lord, permitted by Chogyal and his, my lord, code, who will get his name registered. Now, my lord, these are the original, this is what they have referred to old Sikkim register. My lord, this old Sikkim register my lord, lordship will kindly see page 98, just for a ready reference, bottom. Commencement date of this proclamation shall be 3rd July 1961. Bottom line, my lord.
Yes.
Here. Now, my lord, lordship sees next page, how the Sikkim register is to be maintained. I will not take your lordship all this. These are the rules, how a register is to be created, maintained. This is there in subsequent pages till page 102. I'm not taking your lordship to that. There is no contention. Now, my lord, there is only one portion where your lordship has already seen. Those who don't fall into this category, if they don't have any other, my lord, nationality, have not acquired or they have surrendered, they can also apply. The Chogyal will grant them Sikkim nationality. That is there. In the rule also there is a provision for that. My lord, I'm skipping all these things. Lordship may kindly come to page 178 next. My lord, this is post merger. 21st, Government of India Ministry of Home Affairs so and so are published in general information. Persons of so and so, my lord, Citizenship Act will come to force in the state of Sikkim. Lordship says, my lord. Next is bottom, SO 217E. In exercise of powers conferred under Section 7, the Citizenship Act, so and so, the central government hereby makes the following order, namely, the order may be called Sikkim Citizenship Order 1975. Every person who immediately before 26th of April 1975 was a Sikkim subject under Sikkim Subject Regulation 1961 shall be deemed to have become a citizen of India on that day. And kindly see the fiction. Citizenship Act comes to force. Everyone is an Indian citizen, but the old Sikkim National Register was maintained, and that is made a base, my lord. Every person who immediately before so-and-so was a Sikkim subject. So the concept of Sikkim subject is not abolished. Under the Sikkim subject regulation shall be deemed to have become a citizen of the country. Now, my lord, this is amended in 1989. Kindly come to page 188 for a moment.
By the way, just we are asking for our own knowledge. What is the difference between the Chogyal and His Highness the Maharaja of Sikkim, which is referred to at page 179?
Chogyal is the Raja. Raja in Sikkim.
Why this transition?
My lord?
Why this transition at page 179?
179. Adaptation of
connotation is His Highness the Maharaja of Sikkim.
My lord, because my lord, the this is published from Delhi.
Okay.
But Sikkim House existed in Delhi probably prior to 1960, the present Sikkim House. My lord, kindly come to page 188. This is in modification of the earlier. This is 20th of March 1969. It's by Government of India, Home Ministry. In exercise of powers.
Page 188.
Page 188.
That is 3rd April 89.
My lord, this
20th March
we
89.
come
Yes.
to next. Yes. 3rd April is published. This is actually a notification dated 20th of March 1989. In exercise of powers conferred under Section 7, Lordship got it, madam, of the Citizenship Act 55, central government hereby makes the following order to amend the Citizenship Order of 1975. We read it. This order may be called Citizenship Amendment Order 89. In Sikkim Citizenship Order 75 to paragraph 2, the following provisos shall be inserted, namely, provided that any person whose name was eligible to be entered in the register maintained under the said regulation, but was not so entered because of any genuine omission, shall also be deemed to have become citizen of India on that day, if so determined by the central government. My lord, this speaks why clause 2 in all those things were inserted. Clause 1 is Sikkim register. Clause 2 is who should have been there in the Sikkim register but were left out. Now, my lord, kindly come to page 189. Kindly see how it transited. Page 189. This is dated 3rd of April 89. My lord, a committee is constituted by the central government to look into the cases of genuine omissions in terms of Sikkim Citizenship Order 1989.
Yes.
My lord, kindly come to page 192 and 193. I'll end disturbing your lordships now.
Yes.
My lord, in exercise of this committee formation and all, 192, this is dated 15th April 1991. The following order so and so is published. Order, whereas under the merger of Sikkim with Union of India central government promulgated citizenship order, lordship may skip, whereas it is brought to the notice of the central government that there were large number of persons who were eligible to be entered in the register maintained under said Sikkim regulation, but were not so entered because of genuine omission. Whereas the central government issued Sikkim Citizenship Order 89 providing for such case of genuine omission should be reviewed. And then next, my lord, whereas the state government of Sikkim reviewed all such case of genuine omissions, and whereas the central government, the Ministry of Home Affairs, after due consideration of the applications under the relevant document determined by the order is so and so persons were Indian citizenship with a citizenship order, whereas the central government carefully examined the cases of 33,348 persons. Kindly see the number, my lord, more whose details are given in the enclosed list and have found them eligible to be included in the register maintained under Sikkim Subject Regulation 1961. The central government, after careful consideration of this so and so, 33348 persons hereby determines that all those persons be deemed to have become citizens of India with a from so and so in terms of Sikkim Citizenship Order. My lord, next page is lordship may not trouble your lordship. There is another exercise by which about 40,000 and odd were also included. Thus, the total number came to 73,431. Bottom. My lord, I stop here for a moment. Here is the entire story of Indian national versus Indian national with Sikkim origin. And what is the reference? Indian national with Sikkimese origin get the preferential treatment under clause 4.4 of that establishment regulation, which is the bone of contention actually. Now, 4.4 validity thereof, my lord, naturally it came to my mind, I asked him, fell from your lordship also. Any person with the basic connotations of Article 14, my lord will say, what is this going on? After you come to India, what is this? No. My lord, under the Treaty of Merger, these laws were saved. Consequently, the constituent, my lord, the parliament enacted 371F. By 371F and the merger treaty, some laws were, my lord, saved. Establishment rule is one of those, my lord, law saved by the constitution. Next is Sikkim subject order. Because if the Sikkim subject order is not saved, my lord, 4.4 becomes redundant and meaningless. My lord, what has happened is This provision naturally was called to question, and Honorable Apex Court in the 1994 judgment state this is valid. My lord, can I, for a ready reference, take your lordship to that judgment?
Okay, as per your convenience, Mr. We are not stopping you at anywhere.
No, but it is already there in your lordship's file. The lordship need not, my lord, there is a compilation like this before your lordship. It is in the first case only. We can, my lord, you can pass it over. Is there, my lord? Huh? Yeah, part over.
Yeah, having it.
My lord.
Is there, it's there.
My lord, my lord.
Yes.
My lord, Surendra Prasad is in page 1 itself.
Yes.
Lordship may straightway come to page 23.
Yes.
My lord, although it makes a very interesting reading for me, who is not a Sikkimist. But anyway, I'll cut it short. My lord, para 23.
Yes.
The next question is whether insertion of the introductory clause purporting to convey the said rules made under 309 of the Constitution of India. So. My lord, lordship may skip. Kindly come to that roundabout in the middle. Besides, the provisions as to residential requirement could always be made by virtue of 16(3) of the Constitution. Therefore, if a provision in the establishment rule appears to offend Article 16(2), since such a provision is permissible by virtue of 16(3), the Parliament permits its continuance by special provision under Article 371(f)(k). The said requirement giving preference to locals cannot be struck down as unconstitutional, and any action based on the said provision would not be inconsistent with Part 3 of the Constitution. That being so, we think that the line of reasoning adopted by the learned single judge in the High Court is not sustainable. My lord, if I have understood the factual gamut on the basis of which probably we have to read Honorable Single Judge's order, is this, my lord. 1, constitutional scheme as it exists today permits clause 4.4 to reserve the preferential treatment to the locals. The locals are termed as original Sikkim subjects. So far as the other citizens of the country who are not original Sikkim subjects, they have to stand in the queue, my lord. This is decided by Surendra Pratap. Having not been able to knock that door, can anyone now come and say that by way of an insertion, I have limited the scope of getting certificate of origin, because my lord, without certificate of origin, even a non-Sikkimese cannot come in the queue. I have limited it to grandchildren by to sons and wives only by way of insertion in 1996. And not only that, such issue of COI is only for the purpose of employment. Number 1, whether it's an insertion at all. Number 2, as your lordship, it is rightly fallen, my lord. If it is basically inconsistent with Constitution, 1976 or, my lord, date will not matter. Whether it is inconsistent with the constitutional scheme. My lord, we have seen the 3 sets of facts. One is the regulation part of 4.4. Other is the Sikkim subject. How the Constitution permits within the state to have 2 sets of citizens. My lord, once your lordship comes to this part of India, the lordship sees it evident everywhere. My lord, Meghalaya, entire Meghalaya covered by 3 district council. I can't buy any land, my lord. I cannot even sell a land to my wish. My lord, no total prohibition, regulation. Similarly, 80% jobs in almost all tribal states are reserved for local, my lord. In Arunachal Pradesh, they call it APST, not even Assam scheduled tribe, Arunachal Pradesh scheduled tribe. This doesn't offend. Constitution has found, my lord, that 16.2 is offending. Come to 16.3.
That's right.
My lord, when for 16.4 was offensive, they came up with 4A. So my lord, 16.1 is not a definitive, my lord, single jacket formula clause that any violation of these amounts to 14. The losses will immediately fall back upon the other residuary provisions to save it. Hence, it was said. Having failed on that connotation, they come up and say, no, I was otherwise permitted. You see, only in 1996, by way of an insertion, I again put it the word in my mouth, my lord. They have done it and they have reiterated in 2006. First of all, it's not an insertion. I'm sorry to repeat it. Number two, whether it offends Article 14 and 16. In the line of Surendra Prasad, it is too late in the day, my lord, to again examine this provision. My lord, neither, my lord, this employment rule was put to challenge. The domicile rule is not put to challenge by anyone. Having not put that to challenge, domicile or the land rules, this is not challenged anywhere. Everyone knows, my lord, under 371 FK, all these things are saved. So for the purpose of Sikkim, Sikkim came to a part of India under special provisions with a treaty, and that treaty is saved by the Constitution. It cannot be looked into even by the Apex Court. Having come to this legal finding, can we today say, my lord, these provisions of 1996, when it reserves it to the level of sons, daughters, and wives, and excludes grandchildren, the lordship has seen 1961 onwards, son, daughter, minor child. Now minor is gone. Son, daughter, everywhere. From 1981, we say, first we say, Sikkim subject, and it's for the purpose of employment only. I'm not again taking lordship back. 89, for the purpose of employment only. And then it clarifies that previously, district collector and other people were, no, now it is only district collector. 1996, we again reiterate, in fact, include, there is an insertion which is not under challenge. Clause 4 is inserted, that other citizens are to be treated like this. But when it comes to clause 5, insertion of which is under challenge, there is no insertion. This is all, my lord, repetition of what has been stated, what is being stated since 1976. My lord, I am very sure they will take your lordship to the entire gamut of the judgment. Probably I will not burden your lordship with that. I know, my lord, your lordships know the content of the judgment. Article 14 and 16 doesn't operate in void. My lord, because my learned friend doesn't have a specs and I have a specs, my lord, is Article 14 stretchable to the extent and tell, my lord, that I have to read your lordships, my lord, notifications without a specs? My lord, my having used a spec which is permissible, he not having a spec, my lord, will not violate Article 14. Same is here. My lord, my lord, challenge under Article 16, having been set at naught, Article 14 doesn't operate in void, as because it is valid by Article 16, it will be valid by Article 14 also. Supreme Court having once settled that notion, my lord, it's too late in the day now to come and tell there is an insertion which is not there. Presumably, it is an insertion which it is not. It is not violative of Article 14 or 16. My lord, it is at least from the reading of the judgment, there is no basis anywhere to show that this clause is violative. Because these clauses to become violative, my lord, in the sense of give and take, I was supposed to get something which I am not getting. I was entitled to get it. I was getting it, and you have debarred me. That's the factual foundation. Then we see, my lord, whether that debarring clause is offending or not. My lord, with my lord, folded hands, I'll say, I failed in my exercise to point out or to fish out any such inconsistency on fact which may even give rise to a touchstone formula of Article 14 or 16, so as to judge 1996 and 2006 notification. My lord, yes, the length and breadth is this much, subject to what falls from your law.
One question,
my lord.
But you see, in my original parent high court, or even in the Guwahati High Court, whenever the validity of a statutory rule or notification is to be challenged, there is specific provision in the rules that the matter is heard by a division bench. Why it was taken by a single bench?
First of all, that's why I tell you, my lord, something which they could not do directly, they have tried to do indirectly. There is no rule under challenge. Can
There
you
is
see?
no rule under challenge. Okay,
There is no rule under challenge. Why,
so
my lord? There is a
statutory
written-
notification is there.
My lord?
A statutory notification.
Yes,
So statutory notification is also covered by the same restriction.
yes, at least in my high court it is.
What about Sikkim? Have you got the rules?
My lord, we'll see it in the.
You'll,
My lord, at least one thing. Here, directly or indirectly, they're again casting an aspersion on the virus of 4/4 or any
so
preferential.
that's why,
treatment
Mr.
clause.
Devi, are asking that a statutory notification for its validity to be questioned, the matter is to be placed before the
Division
division bench. What is the position of the rules? We would like to know.
My lord, I
It's
could-
a question of the cuff, but should have struck
Yes,
at the inception.
my lord, number two, I was not very willing to tell. My lord, in a given case, the lordship strikes down a rule or statutory notification, whatever, an executive notification, say. Would your lordship rewrite that? No.
We can read in something that's permissible. Reading into the rule, that is another concept in the principles of interpretation.
My lord, I will stretch myself a little further. In Vishaka, what your lordship did.
We have
when there is a
legislated.
void-
That is a legislation.
Yes,
Yes.
my lord, judicial legislation is permissible as a.
Yes, yes.
But my lord, when there is a rule and the statutory notification is flowed under the rule, having read down the rule rightly or wrongly and recast it, not only that, telling the government, do it today. My lord, I am very sorry to say, in spite of, my lord, showing the cause list, my lord, single judge today took up the matter at Gangtok, lambasted my AG. My additional AG is with me, lambasted my AG, telling that bring an order within 19th or your chief secretary must buy his tiffin career for jail.
There is no stay on the order.
There is no stay of the order. My lord, because my lord, we all agreed that, my lord, we will not press it. My lord, there is an order to the effect that they will not press the contempt.
So why-
Now
why-
they're pressing the contempt.
Why was that not brought to the notice of the learned single judge?
My lord, it is brought
Which
to the
is
notice.
that order?
It is.
Please tell us.
देखो तो। My lord, we have filed a bunch of orders today. It's only a reflection of the Sikkim High Court. My lord, it's only a reflection of the, my lord, is it there before your lordship? We filed it yesterday. It is not a pleading. Lordship may kindly see, these are all orders
No,
of the
we don't have
contempt
it.
case.
We don't have it, frankly speaking. We're not having it. Where do you say that understanding was noted?
My lord,
They will not
yes,
be
I
pressing
think
that.
it is there.
That is in the
Adjournment
Sikkim
of
High
the
Court.
petition, it will notice, Advocate General is present for the Advocate General submits an appeal pending for the submission for the list is matter on 19/9/2023.
It may be considered along.
Issue notice and show cause notice as to why it should be taken. Submitted line Advocate General matter will be adjourned as a listed. Right. अब यहाँ में आइए कहाँ है ये लिखा
In the main rate appeal, it was to be heard for that.
in the writ appeal there can be a stay of contempt of claim.
But
Yes. What happened? Anyhow, you find out. One more question, Mr. De.
My lord.
You've got copy of the order sheets of this writ appeal.
Yes.
Read the order dated 7th December 21.
Two line anybody?
And the order dated 15 December 21.
Right to TDS I call it.
You don't have the copies.
I don't have the copies for.
You will pass it on to you. 15th, 7th, first read 7th December, then 15th.
I'm so obliged, my lord. I'm sorry. I'm sorry for
So
that.
that will have some bearing on the fate of this appeal. or maybe you would like to address the court on this event. Read the earlier one first,
My lord.
7th December.
Part so and so person order
So read the earlier one, 7th December,
70.
the one prior to this.
My lord, my
No, it will be, it's in the other, in the reverse. The earlier one is
Yes, yes, yes.
up ahead. Yes.
7 December, my lord, I get it. Heart says so and so land council appeal for the applicants. Also heart can do this so and so. During the course of argument, it transpired that the rules of business under clause 3 of so and so needs to be seen.
Yes. Now read the
Let a
15th
copy of the
December.
same be placed before the court. In addition to that, let affidavit be filed by secretariat level officer of the government of the team. Bringing on record whether the office memorandum so and so was passed by the government of Sikkim in exercise of its powers under 371 FG. Yes, it was filed.
Then let's look at the 15th December order. Whether you would like to clarify on this aspect.
Hearts so and so, so and so. Person to order, so and so, principal secretary has filed an affidavit. The heart, using the post of the argument, transfer the rules of business clause 3, so and so needs to be still. Let a copy of the same in addition to filed. Although a copy of the rules regarding to has been endorsed with the affidavit, the reply is to be evasive in as much as it does not explain in clear language whether the memorandum dated so and so was passed by the governor of Sikkim exercise of the powers under Article 371 FG of the Constitution, which I say the notification of so and so has been issued. The objective of identifying the scheme subject. Though the names of the agents of I say that depend on the subsequent notification when necessary in order to make the provision rule for the workable. My lord, it is apparently under 371.
That is the observation of the court on an earlier date. We will
I
have
say
to
that
dispel this doubt.
we must record that our query remains unanswered. That is to no reply as to memorandum dated. My lord, can we not, my lord, I'm just speaking out my mind. Is it not a matter of interpretation of your lordship? My lord, we never, I have not seen, at least in my short career, my lord, any order of the government coming out that it is in exercise of the rules of executive business.
No, rules of business in exercise of the powers conferred. So and so. That has to be there.
My lord, it is there that to make the statutory rule workable, this has been issued. And your lordship will see whether it is outside the ambit of the statutory rule. It is not. 1961 clause 44. Read together. Nothing said in the 1995 regulation, or for that matter, right from 1976, is outside the ambit of these two statutes. I've showed to your lordship specifically. My lord, whatever is there in clause 44 and Sikkim subject order, we have just reproduced
that. So your basic fundamental argument is there is no insertion as was read in by the learned single judge.
My lord, neither by way of time nor by way of transgressing the statutory provision. There is no insertion.
Okay. Let the matters. Yes.
My lord, I'm so blessed, my lord. Very sorry.
But your,
my lord, there is an order, I think, which comes to my rescue. So far as the contempt is, my lord, next day of the contempt is 19th. My lord, my
19th of October. 19th October. What is the order?
No, here the order is 22/6/2023 of your lordship's file, my lord. 22/6/2023.
Yes. 22/6 or 22?
22/6.
Yes.
Of 23.
Yes.
Heart counsel admit prayer for interrogatory option so and so shall be considered when the appeal is finally heard. Thus, IA so and so is disposed of. Now, my lord.
What was the IA?
IA is for stay of the operation of this.
Stay of the.
No, my lord. In spite of all these things being brought to the notice, my lord, I'm very sorry to say, my lord, the contempt is being pursued. Today, my lord, how can I procure an order from your lordship, my lord?
That's right. That's right.
First of all, the day. And how can I procure it telling that it's in my favor?
That's right. It's
my
not
lord,
fair on
one
that.
thing, my lord.
But is it correct that you are pursuing the contempt?
Yes,
Even
yes,
today.
Lordship,
All right, then we'll stay the order specifically today.
Lordship,
After hearing you, we'll stay the order. This is utter nonsense.
On Tuesday, Lordship, my.
Madam, the appeal is being taken up for hearing.
Yes, sir.
Why are you to insist for execution of the order? All right, we'll take it into account. you address your arguments.
My senior, Mr. K. N. Chaudhary, sir, will be.
We are not waiting for
addressing
anyone now.
Tuesday, Lordship.
We are not waiting for
I'm
anything.
just,
All right, then we will record this. Arguments have been advanced by Mr. Day, senior advocate, representing the appellant. When the matter, the respondent side was asked to address their arguments, then counsel MS, your good name, please.
S. Chakravarti.
S. Chakravarti states that she is led by senior advocate Mr. K. N. Chaudhary, who is not available right now at this point of time.
May I be
At this,
allowed to call him?
yes,
I may be allowed to call him, Lord.
we don't know, do whatever you want. At this point of time, Mr. Day and senior counsel urged that the matter has been fixed for final hearing with the understanding of the parties, and in spite thereof, the respondents are pressing for compliance of the learned single bench's order in the Sikkim High Court. And what is the order passed?
My lord, notice was issued, it was placed today, it has been placed for further consideration on 19th.
And the next date fixed in the contempt proceedings is 19th October. In view of the peculiar facts of the case, and since, the respondents' counsel is not available to address the court, in spite of the fact that the petitioner's appellant's counsel has concluded his arguments, we hereby stay the effect and operation of the impugned order.
It may be on Tuesday, Lordship, for the
List
reply.
for
Third of October.
arguments on behalf of the respondents on, not on 3rd October, it will not be possible now.
This 5th is a connected matter at Gangtok, I have to go there again.
No, 3rd, we have already fixed many, but today we had time,
Yes.
but if they are not available, 7th November. Okay.
Deeply obliged. But your lordship mentioned that it will be part heard. I'm just mentioning.
Heard in part only, mentioned, heard in part, yes. Of course, it's a hearing matter and we have already recorded that your arguments have been heard.
My lord, yes, subject to
Yes.
what they say. My one,
By mere recording that your arguments have been heard,
my lord.
makes it clear that it's a parted matter. Yes.
Deeply obliged, sir.
Item number 4.
Ms. Day, we can record that it will not be proper for the learned single judge to proceed with the contempt proceedings till, don't stay, just make an observation. We feel that it is not justified for the respondents to press for compliance of the impugned order when the final hearing of this appeal has already commenced. That should suffice.
Yeah, not from the respondent, there are other people.
And my lord, there are other people who have filed a contempt.
Doesn't
Who are
matter,
not
this
part-
order will take care of the
My
things.
lord,
Yes. You can place the order before single judge, I think.
My
That's
lord,
good.
second judge at Gangtok,
Yes,
Sikkim High Court.
copy of this order may be placed before the honorable single judge hearing the contempt proceedings. Yes.
Deeply obliged.
May it please your lord.
Yes.
This matter has been restored to the file pursuant to the order passed in the review petition 104 of 22, lordship,
Yes.
in which the review was allowed. Lordship, this appeal is directed against the learned single judge's order, lordship, which your lordship will find at pages 73 to 79. The issue before the single judge was whether the writ appellant who is before your lordship is eligible to be appointed.
You are against the appointment of the respondent number 5
Yes, lordship.
as an Anganwadi worker
Yes, lordship.
based on the place of residence.
Yes, lordship. And
Yes.
in the review petition, which was disposed of by order dated
Yes.
lordship 22/11/22, it had come on record therein that the respondent number 5 was in fact not did not fulfill the criteria.
There was a division wherein the village
Bogoriguri and
Bogoriguri and North Bogoriguri,
Uttar
they were in
Bogoriguri.
different locations.
Yes, lordship.
You are having a copy of the review order that will have a material bearing on this proceeding. You should be seized of it. Why? Why you're not having a copy of the review order? Hmm?
I have been.
All right.
to appear today or
We'll give him 2 days time.
Yes,
Then counsel for the respondent submits that he is not seized of the order whereby, the division bench reviewed the earlier order dated so and so, whereby, the earlier order rejecting the writ appeal was reviewed and the matter was restored back. What is the order of the review? Date of the review order?
Review order is 22/11/22.
22/11/22. He prays for short opportunity to go through the said order and address the court in reference thereto. List on November 16th.
Grateful, Lord.
Item number 6.
May it please your lordship. This matter, your lordship, basically, we are challenging the order of the honorable single judge, whereby the honorable single judge have set aside the punishment of the order of punishment, but has on his own passed an order giving a new punishment that is under challenge before the Supreme Court. The order, your lordship, will find. I'll just read the order, that part. It starts from page 219. And the operative part, your lordship, will find at page 229, your lordship. Just 2 paragraphs, I'll read, that's all, your lordship. Page 229, paragraph 23. Because this part is not challenged, therefore I will not read that. In view of the discussions made herein above, this court is of the opinion that the impugned order dated so and so is not based on.
Parasar, you have not challenged this order.
No.
In your order of penalty is gone.
Yes.
Whether the learned single judge can still again, the court can interfere in the quantum of punishment. That is a subtle principle. Whether once setting aside the order of punishment, court can suo motu impose another punishment.
But
It was a compulsory retirement. The court has just shifted the date. That's all.
on technical ground, it was set aside. my lord.
Whatever.
Yes, yes. my
So
lord.
you should have sought liberty that we want to hold a fresh inquiry.
But,
You could have done that.
fact is that,
It's not even a fresh inquiry. You're reviewing the authority, ultimately the decision-taking authority, disciplinary authority, disagreed with the finding and imposed that punishment, right?
my lord,
So then you should have asked for a remand. You never asked for it.
at this stage, my lord, yes, my lord, we don't have any such type of instruction till then. But fact is that, my lord, regarding reinstatement in a pyramidal report, petitioner is 53 years old. That is. has to be
You take a
considered.
decision, you take him back on job and then take a fresh decision that is not fit to be retained in service. How
They
the
have a board here.
court can substitute itself in the place of a disciplinary authority or an appointing authority to hold that he is not fit for the job.
Yes.
We had a director general of police in Rajasthan who at the age of 60 years used to run marathons and beat younger people. Hands down. So where do we get this satisfaction from that he is no longer fit to perform duties? For that matter, any other person of 53 years in your force, is he not fit to perform the duties?
But they are.
So that is the only criterion,
They're-
53 years.
They're doing in the meantime, my lord, there is a 13 years of gap. And in the.
So he may have been keeping fit. We don't know.
Yes.
At best, it could have been that you examine his fitness. And then there are cases wherein a serviceman is injured in duty. What do? You give him a desk job. So do that in his case also. But whether the writ court can substitute the punishment after having set aside the same in exercise of the writ jurisdiction, that is the question which he is posing. Is it permissible? Give us one judgment. You've got any judgment to the contrary?
Yes. I've
Let's
got
see.
judgments, your lordship. There are, in fact, the honorable court has stated those judgments but they have not recorded it. I'll give the judgment.
Let's,
Your Lordship.
let's see one judgment.
There are three judgments, Your Lordship, which I refer. First is 2013, 10 SCC, 324, Dipali Gundu Survase. This judgment was subsequently followed in a subsequent judgment that I'm giving, Your Lordship. This judgment, para 22, 23, 24, and 38. Your Lordship. Here, the specifically it is stated in this, full idea.
Para 22.
10 SCC 324.
Yes, para 22.
Para 22 first, Your Lordship. The very idea of restoring an employee to the position which he held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been put for the illegal action taken by the employee. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot easily be measured in terms of money. With the passing of the order, which has the effect of severing the employer-employee relationship, the latter source of income gets dried up. Not only employee concerned, but his entire family suffers grave adversities. They are deprived of the source of sustenance. The children are deprived of nutritious food and opportunities of education and advancement of life. At times, the family has to borrow from relatives and other acquaintances to avoid starvation. These sufferings could continue till the competent adjudicatory forum decides on the legality of the action taken by the employer. The reinstatement of such an employee, which is preceded by a finding of the competent judicial, quasi-judicial body or court that the action taken by the employer is otherwise the relevant statutory provisions or the principles of natural justice, entitles the employee to claim full back wages. If the employer wants to deny back wages to the employer or contends the entitlement to get consequential benefits, then it is for him, her, to specifically prove and prove that during the intervening period, the employee was gainfully employed. Then, Your Lordship, the next, this is with regard to back wages part. Then, Your Lordship, there are 24.
Ms. Manan, you will get dozen judgments of Supreme Court wherein back wages have been denied.
Yes.
There are number of judgments. So this is not the only view.
Yes.
There are judgments to the
There are
contrary.
other judgments also, Lordship.
So-
Correct. But this judgment actually was subsequently also followed. That is very recent judgment that I do not have the, Your Lordship. I couldn't get the such a the citation here, but I got a copy of the judgment. I'll forward it to GD. I'll hand over another, but for a moment, Your Lordship, just one copy I have. I'm giving it. Here, Your Lordship, this particular judgment has been followed in that Your Lordship find in paragraph. This is a very long paragraph. Starts from paragraph 10. Here, Your Lordship, the Honorable Court has, in fact, para 10, Your Lordship, you find at page 7. The same judgment that I have referred to has been referred and has in the next page, page 8, last paragraph, it is specifically stated, it is undoubtedly true that when a question arises to whether the back wages is to be given and as to what is to be extent of back wages, these matters which will depend on the facts of the case, as noted in Dipali Gundu, Survase, in a case where it is found that the employee was not at all at fault and yet he is visited with illegal termination or termination which is actually advised by malice, it may be unfair to deny him the fruits of employment, which he would have enjoyed, but for the illegal mala fide termination. The effort of the court must be to then to restore the status quo in the manner which is appropriate in the facts of each case. So this is on this basis of the facts, Your Lordship, he is entitled to go back to the status quo position where he is left. This is
what was the punishment originally proposed?
Originally, he was given, Your Lordship, initially he was given one increment was cut for 3 years, Your Lordship. Then this was enhanced.
Reduction of time scale for pay for 2 years.
2 years. An increment for 2 years. And then after that, Your Lordship, it was enhanced to compulsory retreat.
Yes.
So after that, Your Lordship, we have come before this court. Initially, he filed the matter before the Patna High Court, but subsequently it has come here. Then this order was passed. This is basically the case. Then court held that ultimately the judgment says that this is not the proposition law has not been followed and the rule has not been followed at all.
Yes.
So therefore, it has been set aside. Now, the second part, Your Lordship, I am agree with only the second part that he should have been reinstated. My only argument will be, Your Lordship, is that yes, if he is not fit they normally have a board, your lordship. Whatever happens if an employee is not fit, then they have a board, you refer to the board, board will say whether he's fit or not, then they take a decision on that. But this cannot be, just this honorable court cannot take a decision. That's basically.
Do you have any law on the aspect of back wages in such circumstances?
Back wages part, your lordship, this case itself
This
says
judgment you have cited.
back wages, yes. In the same
Yes.
case, gives, and one more case that I have,
Hmm.
that I'll refer to your lordship, where this back wages part is been taken care of. That is 2016, 16 SCC, video. 16 from here. 15. Page 663.
663.
Yes, 16 SCC, 663. 16 S. Here is just a very short judgment here. There are three of the judgment. Having given a thoughtful consideration to the controversy, we are satisfied that after the impugn order retirement dated so and so was set aside, the appellant was entitled to all consequential benefit. The fault lies with the respondents in not having.
This is after the order of termination was quashed.
Yes.
Suppose that period they did not utilize.
Yes.
In that circumstance,
Yes, in
Supreme
that
Court also.
circumstance, court says that he is entitled to, subject to the whatever payment has already
But
been.
this is not a period wherein the employer is at fault. The order of termination was operational. We set it aside only in the year 2023.
Yes.
So post 23, that's a situation.
Yes.
It's a different situation.
The only thing,
Here-
your lordship, he has been given the compulsory retirement. That means he's been given pension. Pension.
Pension is, he is drawn.
He has not drawn all. A part has been given to him. Subsequent, after this order has been passed, the pension has also been stopped. I don't know, because they are, I think, following this order and maybe they are calculating it. I don't know. So it has been totally stopped now. So that part, your lordship. And
Well, let's see. Okay. Anything to say?
My lord, yes. My lord,
Yes, you have, wait a minute. He's citing some more text. Yes.
in the third judgment, this is also, your lordship, I'll just rely on one paragraph. This third judgment is the 2015 SCC 184.
Yes.
Para 24 and 25. Para 24, I'm not going to read, your lordship, is the same, your lordship, earlier case that
Dipali.
Sura Varse case
Yes.
that has been referred again in this matter. Dipali Gundu Sarvase. So I'm not reading that. Para 25, the court has come to a finding that for the reasons stated supra, we have examined the case state on the basis of the material placed on record and the rival contention asked on behalf of the parties. We hold the finding of the inquiry officer and the charges is vitiated on the account of non-compliance with the statutory rules and the principles of natural justice. In absence of evidence, the order of reinstatement sans back wages is unjustified in law.
But herein is, Mr. Manan, it's not a case wherein he's let scot-free. His finding of guilt is there. It stands. So it's not that case wherein he has been given a clean chit. That's the difference.
Only thing, your lordship, here is that, your lordship, the decision taken was not correct
No,
by the authorities. Concerns this court has held. We are not on challenge on that. So I wouldn't like to go on to that because they have also not challenged that. So
No,
it has become the
that is
again,
the
final.
final, yes.
Therefore, only part with regard to the punishment which has been
Reinstatement and that.
substituted.
Yes. Yes, that's
Substitution
right.
is not
Substitution of punishment, yes.
That is the only part we are agreed. That is basically my case.
Okay, very well.
my lord, only on technical issues, my lord, already, my lord. they-
Whatever technical issue,
yes, my lord.
what was the reasoning behind that extreme punishment in your, that authority's order? What is the reason given? Nothing.
No reason.
No reason at all.
That is on record.
It's
my lord.
not, apart from the revision being time barred,
And
the
on-
revisional authority did not assign any reason also.
9 days time but is there, my lord, yes.
Hmm?
But regarding my lord, considering their my lord, delay in approaching the court also, my lord, and
Delay in approaching the court means?
earlier they have approached the Patna High Court, subsequently they have
So
come.
then
There
they
is a-
approached
there is a-
the, any particular court they have gone,
My lord,
that period is always to be set off.
my lord.
That
And,
can't be counted or attributed to a delay. You mentioned about the fact of Patna High Court proceedings.
Yes, yes.
Yes, yes, that
That has been
that is
stated.
on record, my lord.
Though the judgment does not reflect that, but it is there in the then
It doesn't record, my lord.
We'll see, all right.
Okay.
Arguments have been heard, judgment is reserved.
My lord, only in that case, my lord, if my lord is thinking, my lord, then my lord, it has to be referred to the my lord, board, my lord, it will consider, my lord.
So that for future continuance,
Yes.
retention,
Yes.
perhaps your board can take a decision. But which is the provision? Then in the midst of service, you can check the health parameters of an employee. Show us the provision in your rules.
My lord, no, my lord, fact is that my lord, regarding any promotion and any other cases, my lord, it's time by time, my lord.
That of course, the subsequent service will be as per the rules and prevailing rules and regulations.
My lord.
We are not saying that it's a order, perpetual order retaining him in service in perpetuity, contrary to the fitness or whatever concepts, parameters are there. We are not giving him that kind of clean sheet that he
My lord.
remains in service in perpetuity without fulfilling the requirements of law and the rules. Yes.
much obliged.
Obliged.
Yeah.
Supplementary list, item number 3236.
Check here.
My lord, as per last order dated 26/7/2023, my lord, the government is supposed to give instruction.
Mr. Mazumdar,
The last time I had stated, my lord, there was one letter from an additional secretary saying that we were required to withdraw an affidavit which was filed in the matter, my lord.
you have to withdraw an affidavit.
That was one of the things they have gotten on RTI and they had placed it before this honorable court. I took my specific instructions, my lord. The secretary of the department says that the additional secretary was not authorized to make such a communication. We have to proceed with the matter, my lord. So we now, my lord, we proceed with the pleadings we have done. My
But
lord.
that is just an oral submission. Then you have to file a counter affidavit, additional affidavit saying that
I'll bring that later.
you have to do that.
I'll do it.
Yes,
Because
Mazumdar,
we
please.
have after tomorrow, I can.
Time to file a pertinent affidavit in response to the observation made by this court on 26/7/2023. He may do so within next 2 weeks, list thereafter.
Any date, my lord, after 2 weeks?
It'll come up automatically, don't worry. Okay.